a motion matter. The matter relates to challenging the wideness of a recruitment rule.
Relates to?
Wideness of a recruitment rule. My lord, your lordship heard the matter, my lord. Thereafter, your lordship granted the urgency to before the vacation bench. Matter was moved before the vacation bench, my lord. Vacation bench directed the matter to appear 1 week after vacation. My lord, it's not appearing. Let the matter appear in the list, my lord. And
Give it. Next week it will.
May I have a lordship, please, matter. This matter was heard by the coordinate bench. The matter was directed to appear today, my lord. Unfortunately, the matter is not appearing. We have served notice on the other side. We are the writ petitioners. We are only challenging the point of regularization. We have served notice, my lord.
Lordship, let me see the order.
Second page is the one page order. And we have served them by mail.
List it.
Grateful.
Give the inclusion matters you give.
Lordship, may I permitted to mentioning the hearing? May I permitted to mentioning for hearing, if I may?
No, sir, please wait a week. Please wait 1 week. After next week, hearing matters you may mention.
One matter has been recently assigned before your lordship. It's, my lord, already the notification and advertisement has been issued. And this division bench has passed an order to give the expert report within 3 weeks. The lordship would remember. And, my lord, in that event, my lord, we have filed an application. Application for providing us with the expert report, because already, my lord, the advertisement has been issued. Anytime, my lord, the form fill-up date is declared, my lord, lakhs of candidates are there, my lord. They cannot participate in the upcoming selection process.
No, what report was directed to be submitted?
My lord, petitioners have challenged that several questions were wrong in the TET examination. High Court, my lord, single bench passed an order appointing expert. The matter went to the division bench. Division bench, my lord, made, my lord, subject to its expert, 3 experts. Then again, my lord, the matter was went into the Supreme Court. My lord, Supreme Court SLP was withdrawn. Now, my lord, the board, state board, came up with an application that the previous expert committee, which made, my lord, those expert committee cannot give the answers of few questions. So, new expert was found by the division bench. This time, the division bench said, my lord, within 3 weeks, you have to complete the report. Well, we have filed an application just to give the copy of the report. That is it. Well, it has been assigned to this bench. Your lordship would remember Justice Bishwas was there, one of the
it was found on taking the experts from the different universities. Only the answers are question.
The state. Who is appearing for the state?
Mr. Atul Bishwas is the answering respondent for the West Bengal Board of Primary Education. My lord, it was already, my lord, taken up by Justice Chakravarti, but later on, my lord, it was released, and, my lord, it is assigned, my lord, before this bench. Because
assignment, you have the assignment?
Yes, my lord. This on the bottom. Not just we want the expert report. My lord, High Court directed to give it within 3 weeks. Last time. They were
Can 31.
Can 29, 30, 31. Mine is Can 30.
Can 30 is the application for the report.
Yes.
You list Can 30 on Monday.
Great.
My lord, we are appearing for the petitioner. My junior is occupied in another court for work. So if you can, your lordship can allow us.
In which matter you are appearing? In which matter are you appearing?
It's matter of HON'BLE case.
Item number?
Number 5.
So you will just stand here and start making submissions.
Apologize.
What is this? Yes.
Item number 1.
It has come up at my instant.
Yes, there is an error.
It's a very inadvertent, innocuous error.
It should be Subrata Das instead of
Briganga Path.
Mr.
Item number 2.
Not to, I am for the petition in this matter. But there is a son of the you will also heard this matter on 18th of September, and my lord has
Fight club. लिखे रखो.
Who is for respondent number 6?
we made attempt to serve, my lord. The service is the server is down, my lord. The tag report is not could not be available, my lord. Lord, with regard to our respondent number 6, my lord, we send the copy, but my lord, the tag report we could not, my lord, get hold of the tag report due to server problem, my lord.
So there is no service till date. Say that.
So earlier, my lord, we served. Your lordship directed me to serve again.
So there is a direction for service that is not complied. Get it served. Then it advocate for the.
In this matter.
We have obtained Mrs. Great.
Item number 3.
Advocate.
All right, not today. Not today.
10 minute, kindly make it not this big, because this is the fourth re-adjournment they are taking. And we're coming.
Yes, call the next.
Item number 4.
Yes, Mr. Mukherjee. Huh? He will be busy with something or the other at any time. He has to find time for this also. 2 weeks. None appears for the writ.
Item number 5.
Should let them serve a copy on us, your lordship.
What are you filing?
Yes, my lord. My
What are you filing?
affidavit, my lord.
Reply.
Senior is, my lord, occupied in room, courtroom number 35. So if your lordship could allow us to just hear this matter on like after 2 p.m.
Serve a copy on us because they have not.
So why you have not served a copy? Reply filed by the writ petitioner. On reply filed
18.
Six, my lord, I am for the petitioner. My lord, last occasion, my lord directed me to file a supplementary affidavit and with a translated copy. My lord, may I, my lord? Page 43 of the petition. তারপরে নেই শুধু translation page 43 translation.
Yes, you have to give a copy. Otherwise, how they will know whether the translation is correct or not?
That I have served now. That the father of the petitioner, that the mother of the petitioner died in harness in the year 2013. They are
18.
13,
Yes.
1-3.
16.
Thereafter, the father of the petitioner, within stipulated time, that is after 5 months, applied for the same on compassionate ground. The authority took time since 2013 to 2017. In the meantime, the father of the petitioner got incapacitated, and that
How he
incapacity,
got incapacitated?
my lord,
Why he got incapacitated?
because of severe illness, that I have annexed the medical documents at page father of the petitioner 36 to 45
Yes.
of the petition.
Yes. Then
Thereafter, in the meantime, the petitioner got eligible. He became major, and the petitioner applied for the same. And the authority rejected that. The
petitioner is son.
no, the daughter of the deceased mother.
Yes.
And authority rejected
When she became eligible, on what date?
on 29th October 2018.
And the father, when did he withdraw the candidature? In 17 itself.
No, in the year 2022,
He has written that in his place the daughter should be considered.
my lord.
6 September 22.
22. The authority rejected that I have not applied within stipulated time, and at that time I was a minor. Now, my lord, they referred clause 6cc of that notification, and that notification subsequently deleted. My lord, I have annexed that notification also at page 64. 6cc, the deponent member shall invariably attain the minimum age for recruitment within 6 months from the date of death or incapacitation of the concerned employee. Revised provision deleted at page 64, 1-2, column 2. This is my case, my lord.
So 6C, if it is deleted, then still 10AA will apply.
10AA will apply. 10AA is belated request. But, my lord, the father applied within 5 months. Now, compassionate ground is not a right, but
Mr. Mukherjee, in one case, we have passed the judgment, the other bench, where the claim of the other person was rejected that it is not transferable. Their reason was assigned that it is not transferable. Can you please assist us where that judgment is, if it can be, so that we don't, just to avoid any inconsistency, we want to see that judgment. Yes. Claim is very much similar. We don't know, but it is the same thing. He has said that nobody wants. No, on the very same day, or he has said that the petitioner will apply. Where is that withdrawal by the father?
At page 4 of my supplementary affidavit, the translated copy.
That is why we wanted the translated copy.
Right.
Yes, so in his place, he has said that the eldest daughter be given.
So to see,
Yes, yes.
that is the
Part by
position
time.
here.
Here they said it is not transferred. It's not abandonment. It is not abandonment. Therefore, we said, let us see that judgment. You are quoting from that judgment. Let us see that judgment. And whether you have that judgment is still holding the field, or you have questioned that judgment, we should also see. Maybe a couple of months, 1 month, maybe prior to the holiday or something like that. So please, if you can find it, then you please contact him, get that judgment. The same issue we have decided. I don't remember. The issue arising for
Item number 7.
The petition remains, Lordship.
Lordship, in this matter, Lordship, that the advertisement was eventually issued, eventually, Lordship, by the West Bengal Health Recruitment Board for direct recruitment to 3 posts. 2 posts for the undeserved category and 1 post for the AC category.
Which post?
Lordship, the post for of Inspector of Drugs. Kindly see page number 37, eventually, Lordship, of the writ petition.
Yes, then what happened?
Then, eventually, Lordship, the petitioner participated in the examination, eventually, Lordship. In the in advertisement, eventually, Lordship, kindly see, Lordship, that a candidate should verify from the notified rules that he or she is eligible. The conditions prescribed cannot be relaxed. The recruitment shall be made by selection, but where a large number of applications are received as a result of advertisement, the board may, for the purpose of shortlisting, hold a preliminary examination. Now, Inspector of Drugs, ISM Drugs Council, 2 posts for the undeserved and 1 post for AC category. Lordship, the academic qualification, academic and experience. Lordship, that's a degree or in pharmacy or pharmaceutical science or medicine with specialization in clinical pharmacology or microbiology from a university established in India by law and shall have undergone practical training in the manufacturing of Ayurvedic of Unani drugs as the case may be. This is the degree certificate submitted by the petitioner, eventually, Lordship. Now, eventually, Lordship,
Which certificate he has submitted?
Lordship, that is the experience certificate that shall have the undergone practical training in the manufacture of Ayurvedic, including Siddha or Unani drugs, as the case may be.
So you have submitted certificate. Where is that certificate?
Yes, Lordship, I'll present it. Lordship, kindly come, eventually, Lordship, the page number 41. Certificate কোন page আছে না? Yes. Lordship, first, as per Lordship's query, kindly see page number 87. This is the experience certificate, Allen Laboratories Limited. Manufacturing chemist, tablets and biochemic designation. Lordship, that's the manufacturing. This is the, as per the advertisement, his experience required, eventually, Lordship, that the practical training in the manufacturing of Ayurvedic, including Siddha and Unani drugs, that is a manufacturing chemist, page number 87. Now, the interview letter was eventually issued, eventually, Lordship. Page number.
No, this
40.
is the letter of appointment. Where is the proof of experience? After this, whether he was appointed, if so, how long he worked, what work he did he do? See, this is an offer of appointment.
It's the offer letter. Thereafter, eventually, Lordship, the confirmation of service, page number 89.
Yes. No, where is? See, it says practical training in the manufacture of. So where is the document which shows that you have been trained in manufacturing?
Page 89, eventually, Lordship. Can you see confirmation of works? The management of the company has reviewed your performance.
So what is the issue? What is, yes.
Issue is, my lord, I relied on the advertisement and, my lord, the constitution of the health recruitment board, my lord, is a sequel to the replacement of, my lord, the Public Service Commission. Now, my lord, they talked about, my lord, a new rule of 1995. And by virtue of this new rule, my lord, the tenor of the advertisement, my lord, stand modified and our submission, my lord, could not hold water. Why? Because, my lord, our submission is what is the issue behind in this writ petition. Issue is, my lord, I submitted all the documents as required. They said you did not. I said, my lord, that in this particular rule, they said, I said under the old rules 1965, it was not incumbent. There is no mandatory, my lord, consequence in case of failure, my lord, even if, assuming not admitting, my lord, that is the case. What is, my lord, the reply? Kindly
so you are relying on 65 rule.
I rely on 65.
And they are, yes.
They said, my lord, new rule has come.
95.
Now, they said
1995.
Yes, 2012. I stand corrected. Your lordship possibly Judge Sahab's file. Your lordship was provided with this particular rule supplied by the state dated 1st August 2012.
Copy was given to you also.
Yes, absolutely.
Yes.
Provided by the Honorable Bench, Millard. Now, Millard, this notification issued in the name of Governor in terms of proviso to Article 320, Subrule 3, Subclause 3, and it has been relied by the state, whereby certain services as specified under paragraph C, subparagraph 1 had been delinked from the purview of the West Bengal Public Service Commission, and instead West Bengal Health Recruitment Board had been created. Now, Millard, this notification, if your lordship may kindly take note of this, it merely speaks of delinking of certain posts from the West Bengal Public Service Commission, but does not represent any recruitment rules as had been produced on behalf of the petitioner, which dated back to 1965. I will take your lordship's cursory, I have your lordship's cursory glance again, Millard, to 1965. And at this juncture, Millard, the notification dated 1/8/25/12, which states inter alia, Millard, that the existing recruitment rules for each category of the post will remain valid mutatis mutandis until further orders, and the West Bengal Health Recruitment Board will select candidates as per these recruitment rules. Thus, Millard, this provision makes it clear that the notification dated 1/8/2012 does not effectuate any change in the relevant recruitment rules governing the post of, Millard, Inspector of Drugs, to which the petitioner had sought appointment. Now take, my lords, kindly take pain, Millard, to turn, Millard, the Rule 1965.
So did you challenge this advertisement?
Which one?
The advertisement.
No, I said, Millard, that if the advertisement, the law is, Millard, subject to correction. If any notification, the part of the advertisement, Millard, if it is contrary to the rules, Millard, there must be an harmonious construction.
There must be
a harmonious construction. The rule will prevail over the advertisement.
that construction will come into consideration only if a challenge is made that it is not consistent with.
Millard,
If you apply without
What is-
questioning any of these issues, then can you raise this issue?
Millard, today I am not questioning, Millard, the terms of the, I said, Millard, the rule says. I said, Millard, rule says.
No,
that-
you said this advertisement is to be read as per that rule.
No, I said, Millard, they said that the tenor of the advertisement stands modified
If
because of.
if that rule was applicable, then this board
Millard,
would
that
not
is-
have
that is-
published.
Millard, what is my relief?
If the earlier rule is applicable, then this board would not have published the advertisement.
No, I am coming, Millard.
You
Kindly
know
take-
that the board has taken place.
I am pursuing your lordship, Millard. Kindly take pen to page 34 of your lordship's brief.
No, what
the
is your
petition.
brief? Come to the OA.
An order, yes, coming. That is, Millard, I am extremely grateful for your lordship's, Millard, kind consideration. Page 34 of the lordship's brief.
That
your
is the
applic-
OA.
OA. But this is a read petition, page 34.
Yes.
What is our challenge, Millard, thrown? There are 3 posts, 2 for SC and 2 for unreserved and 1 for scheduled caste. Now, what they said, they converted every post. The 3 posts were filled up by the SC candidate. The marks, Millard, had it been, Millard, that was taken into consideration, Millard, I would have been appointed. An order directing the respondent authorities to reject and or set aside the list or panel persons prepared by the recruitment authority for appointment to the post of inspectors of drugs, ISM control such and such, and directing the authority to form a fresh list of persons who have been qualified for such and such control in terms of the advertisement 9th October 2018 having memo such and such. An order directing the respondent authorities to produce the mark sheet and scorecard of the applicant. An order directing the respondent authorities to disclose the minimum cut-off marks for the qualification to the post of Inspector of Drugs, Department of Family and Health Welfare. And further order directing the respondent authorities to keep 1 post vacant, such and such an order. And the first time, the knowledge about my dismissal from the zone of consideration, Millard, that was, Millard, recorded in the order. That is, Millard, the order under appeal, impugned order, Millard, internal page 2. What weighed with the tribunal? Kindly seize, Millard. I start reading from, Millard, the internal page 2 of the order impugned. Millard, responding to the point of limitation raised by Mr. Banerjee, Mr. Bhattacharjee had argued that the final list of the recommended candidates was published by the board only on 26/7/2019. The application was filed on 30th March 2021, which was delayed due to the restriction imposed during the COVID-19 pandemic. coming to the main ground of non-selection of the applicant for being failure to the present copy of the experience certificate, Mr. Bhattacharjee had shown a certificate issued by Allen Laboratories Limited at page 4 of the supplementary application. Question before the tribunal is whether this certificate sufficiently meets the definition as given in the advertisement or not. But more than this, the most important question is whether the certificate was presented by the applicant during the document verification stage. Mr. Banerjee is very emphatic that such certificate was not produced by the applicant at that stage. Therefore, his name was not considered fit to be allowed for the interview. Mr. Banerjee has submitted in this important point on the basis of the statement signed by the Secretary and Controller of Examination, West Bengal Health Recruitment Board. The tribunal has examined the statement of the Secretary of the Controller of Examination, which records non-submission of essential qualification certificate, practical training experience in Ayurvedic Siddha Unani. Accordingly, his candidature was rejected in absence of any evidence presented by the applicant signed. On the contrary, the tribunal is inclined to accept the written statement of Secretary of the Recruitment Board, who being a senior and responsible officer of the government would not have made a false statement before this tribunal. Now page 42, Millard, kindly comes. Why this statement? It is, I am not spewing venom or insinuation to the government officer, but the court's reliance, Millard, to an institutional trust, Millard, upon an institution, Millard, kindly see it creates a contradiction and confusion too. You will be allowed, what is the dear candidate, with reference to our advertisement number such and such, 17/9/2018, for recruitment to the post of Inspector of Drugs under such and such, you are being called for documents verification. You will be allowed to appear in the interview on the same day if all the certificates are authentic and West Bengal recruitment will satisfied that you fulfill the laid down qualification condition, etc. mentioned in the advertisement for the applied post, the date and time such and such. Upon verification, I was called for interview. Otherwise, there was no occasion for the government or the authority to call for interview, Millard, without there being a verification. They were satisfied and they called me for the interview. Where is the statement in the plain, in the petition? Paragraph 2b of the Lordship's brief. The tribunal did not give an opportunity to the government to controvert this. 2b, page 4, Millard, may I be allowed to read for my Lord's kind consideration. Having verified that he possessed the eligibility criteria as mentioned under clause A of the advertisement, the petitioner had submitted requisite application in the proper form within the stipulated time period. And
where are you reading?
I'm sorry, Millard, page 4
Of
the writ petition.
No, come to your OA. Why writ petition? Writ petition is.
His contention was not heard and considered.
So we have to go by the pleading before the tribunal. You cannot make out a new case here or add to the.
They made out a new case and tribunal relied on them, Millard.
No, where is the tribunal has found it to be belated?
I do not know, Millard, why this is deleted. And Millard, on 19 November, page 27, which your Lordship wanted to see, Millard, that where is the pleading?
No, what is the reason why you have not been chosen?
That is for them to answer.
No, you say that your name is not figuring in the select list. In the OA, you say you have appeared, you have performed your best, but your name is not figuring in the select
list. Because the tribunal has said, the government said that it was the reason, Millard, that this point was never considered.
No, why you were not selected? Where is
Millard, because Millard, I have categorically stated that after receiving the application of the applicant for the aforesaid post, the same was shortlisted, and 8th March, a document verification
you come to page 4 of the OA.
Page 27 of your Lordship.
Page 28, Roman 5, where you have stated.
I have stated, Millard, first Roman 3, then 5.
Yes.
That after verification of all the documents, your Lordship is absolutely right.
Yes.
To the utmost satisfaction of the recruitment, the applicant was allowed to appear before the interview, which is in line with the contents of page 42.
So where is the dispute? You are allowed to appear. What does that mean? You have to be selected.
No, it does not say. Then it says, Millard, that 3 posts, 2 for SC, 1 for
Correct.
Unreserved.
So now this issue.
Millard, and what is the reason for which the tribunal disbelieved my contention? No opportunity.
Only issue you have raised before the tribunal is that the appointment is made in excess of the reservation.
Yes.
permissible
This is the
reservation.
legal point.
This is the only issue.
This
you
is
have.
the legal point number one. And the cut-off marks I did not, I was not.
You say that
No, no. This is what
I
is
have
cut-
left no single question unanswered, so I don't know why I have been excluded.
Right.
This is
Number one.
this is your
Number two, yes,
grievance.
I'm extremely grateful, and the government says,
What does the government say? They file a reply before
Secretary, the
tribunal.
non-submission of essential coalition certificate. Why at this stage, this submission, which was verily believed by the tribunal, is absolutely non-honest.
No, no. Where is their stand? From
Their
where do you?
stand is the last page. I'm sorry, my lord, that may I read it again, my lord, for my lord's kind attention.
Page.
Page tribunal's order.
No, no. Forget about what tribunal. If tribunal whatever has recorded is to be taken as correct, then you would not be here. Where is their stand?
Stand is
Regarding
reflected-
your
stand,
disqualification.
my lord, this particular stand, tribunal believed this statement because the written
So
instruction.
therefore now they have filed an opposition.
The
What have they said? We are asking you.
Opposition to the writ petition.
Yes, today they have perhaps you have filed a reply.
The opposition kindly sees. This is the deputy secretary.
Before the tribunal, they said you did not have the requisite qualification, which was recorded by the tribunal.
They said, I'm sorry, Millard, the exact language is non-submission of essential qualification.
Correct. So that is one of the essential qualification is lacking.
Even if, Millard, no, even if I'm armed with the qualification, I did not submit it to you.
So therefore, no essential qualification was submitted, and therefore
Yes.
you were not considered.
And Millard, be that as it may, page 4, Millard, of the affidavit in opposition.
Yes.
Be that as it may I read for my lord 4E, page 4, E. Be that as it may, upon verification of all the documents submitted by the petitioner to the appropriate authority, it was found that the application of the petitioner was incomplete due to non-submission of the essential certificate, practical training experience, Ayurveda Siddha. As such, petitioner was found not eligible for the post, and his candidature was rejected. And at that point of time, then they maintained silence. And then Millard kindly says in paragraph 7, 8 of my reply, what is my response to this, Millard? Reaction, not response, Millard, to the state. That with regard to the statement, allegations and or statement made in paragraph 6 to E, each such statement, allegation, averment is categorically denied and disputed except for the maybe matters of record. It is denied that upon verification of all the documents submitted by the petitioner to the appropriate authority, it was found that the application of the petitioner was incomplete due to non-submission of essential qualification certificate. The petitioner candidature was rejected till such time when the application being way number such and such was taken for consideration, the petitioner had received no information under communication notifying rejection of his candidature due to incomplete application. Moreover, had the application been incomplete, the petitioner could not have obtained the computer-generated acknowledgement slip at page annexure at page 41 of the writ petition issued from the application portal upon successful completion of the same. It may be that due to some technical glitches, the said acknowledgement slip did not reflect the fact that the petitioner had submitted a compressed PDF file containing all requisite qualification, including essential qualification certification. Then, Millard, I said that it is further stated that the marks quoted in paragraph 6H were never disclosed at the time of publication of the notice dated 26 July 19. And in absence of such disclosure, the petitioner had every right to question as to why seats reserved for the general unreserved candidates were filled up by the reserved category candidates. For obtaining such disclosure, there was no need for the petitioner to include every other candidate's party respondent in the original application. That is why, Millard, I passionately relied on Rule 65. If your lordship kindly, the court was confronted with a confusion because of the state's passionate objection that this rule is no more, Millard, in vogue, and new rule has come replacing this one. So 65 rule, page 4, it says a degree in pharmacy or pharmaceutical chemistry or postgraduate degree or chemistry with pharmaceutical a special subject of a recognized university, or a diploma in pharmaceutical chemistry granted by Pharmaceutical Society of Great Britain, or a degree in medicine or science of a university recognized for the purpose having at least 1 year. I am on page 5, postgraduate training in a laboratory under a government analyst appointed under the Act, or a chemical examiner, or a fellow of the Royal Society of Chemistry. 4. A head of an institution specially approved for the purpose by the appointing authority. A chemical examiner, Roman 2. So it does not speak about any experience. Rule 65 is in vogue. After the Rule 65, nothing has come out. That one matter has been taken up. If it's a response, if a lordship feels it's the highest court of the high state Millard division bench, I'm feeling embarrassed, Millard.
What?
To pray for leave. May I come back within 10 minutes? I have concluded. Yes. I'm feeling embarrassed. Go. Your lordship, I will come back.
Then we'll hear you on another day.
I'm extremely
Come tomorrow. Not today.
Your lordship is not annoyed.
Let's see tomorrow.
And next matter is also mine, Millard. I'm praying for.
Yes, both were adjourned yesterday, both are adjourned today also. Yes, the other court is more important.
No, Millard, sorry, no, Millard.
Call the next.
No, Millard, I have not.
Call the next.
Millard, kindly, Millard, I will leave that court.
Call the next. Oh, next.
7 and 8, both. 8 or two. Item number 9. Correct, because the
Yes.
either final or but then that year will fall within March 20. December is tax month. That is not very important.
The paper book has been missed. I'm completely handicapped. Only a day's station,
Lord, I'm fully ready, my lord, because it is running, my lord, for 3-4 days, my lord.
Fellowship, till yesterday I was here. It was on their ground, but inadvertently my brief has been missed.
Whatever has happened earlier is immaterial. Today she is incapacitated due to some reason. Are you agreeable that it comes tomorrow, or you want tomorrow? All right, not today.
Item number 10.
Yes.
Even if the 5, even if it's
The replies.
The prayer of the petitioners is for migration from public health service to health service. Now, the respondent has rejected my prayer, as well as my lord, the learned tribunal has also rejected my prayer on the ground that there is a notification that once the option is exercised for migration cannot be re-exercised. This is the sole ground. Now the point of challenge is that notification. If your lordship kindly come to, there are two aspects. Number one, there are certain discriminations I have referred. They have not dealt with in their opposition, my lord. Simply they have said that they deny the fact. Nothing more, nothing less. And the second point is this: the notification which they are quoting that has been subsequently amended. They have not taken note of that amendment. These are my two defenses. Now, your lordship can come to page 7 of my petition, paragraph 12. My lord, categorically, paragraph 12, my lord, I have said,
If you want to show any averment, you show it from the OA, not from the writ.
Page 61. 6.1, that the concerned respondent has allowed several other medical officers to exercise options even for the second time to opt out from WBPHS to WBHS. The notifications in this regard are the proof on such contention of the applicant. And in my reply, my lord, I have stated who are those fellows. If your lordship kindly take page, come to page 5, my lord. Page 8, I stand corrected, my lord. Paragraph 3 of my reply. These are the people who have been allowed to bypass their own notification.
Where is Annexure D of the OA?
My lord, page. That is a but that is at page 34 of my petition.
32 of?
Of my petition.
That cannot be. That is of 21-22. Annexure D is of 21-22. . This is not the come to page 36.
Yes, ma'am. But,
Perhaps this is annexure D. How do you file like this? It's really surprising. No, at page 61. Notification for the year 2021-22 are hereby marked as annexure D. So this is 21 and 22 document. So perhaps it is page 35 and 36. What is this? Make it difficult for yourself and you make it difficult for us, more difficult for us. Because he has noted on the top opt out at page 35. So perhaps this is annexure D. 35 and 36.
there are number of cases, my lord. No. My lord,
Which page you are referring? 35?
35, your lordship, kindly second one. Dr. Hanuman Mondal.
Yes, we have seen that.
Public health.
All are WBMES. All are WBMES. Another aspect is this is not a option to change the department. This is after resignation. They have resigned from service. They have resigned and then they have joined the new service. It is not a option of changing the service. They found better prospect in the teaching service, so they have tendered a technical resignation and then and page 36. How does 36 help you? Because these are the two documents you are relying.
36, your lordship, kindly come to page 38. Dr. C.C. Biswas. The governor has increased BPHSC Bardhaman under WPPHS to opt out from
That is all right, but this does not appear that it is the second option.
This is the second option.
How? This does.
Let them say, because it's their.
They have already said, they have said they have not allowed anyone. You say this is the proof. But this is not a second option. This doesn't say that earlier he was and now we are allowing him to go back. It says we are accepting his option. From reading, one cannot make out that it is a second option. And you have not stated like anything like this.
In my reply, I have stated, my lord.
You may have, but it does not appear.
My lord,
Cannot be said, and they are not parties, so therefore there is no way that we can go into this issue. From the reading of the document, your government is not supported. It does not say that earlier they were in the West Bengal Health Services, earlier then they have come in the public administration, now we are allowing them to go back. It says with this just an option.
The normal.
So the where is the option that you had submitted? In 2013.
That document is not lying with me. I was joined in the year 2004, and
you joined in 97.
Joined, sorry, 1997, and in 2012, my lord, I opted out.
No, March 2013 you opted out.
Opted out. And again, after completion of my.
And then in 19 you have acquired some educational qualification. And then you say that now I want to go back in the health service.
Because
They say it's not permissible because in 2004 they have issued a memo which says one option can only be exercised. There's no option. Where is that 2004 memo?
My lord, in the compilation list, I have given my lord. If your lordship kindly come to page 89 and 111. 111 of my compilation.
Compilation.
The last copy I have.
Page? You have annexed that 2004 memo. And the proviso after 2 at page 9. Page 11. Huh? Of the writ petition.
That was challenged before the learned faculty. That is the order of rejection. Yeah. Well, after their notification, if your lordship kindly check up 111 of my compilation. That is the clarification or amendment, whatever. The clarification, government issued the clarification on 6th of January.
No, why you have not challenged this? If you have not challenged, how you can get the relief?
Well, it was challenged, but kindly say the order impugned, my lord, before your lordship, the last and having heard the last paragraph, having heard the submission, the tribunal is of the view that the applicant having once exercised that option to, they have taken note of. But the order to.
No, you have not come to your relief. Where have you stated in the OA about this 24 order? In your OA, which paragraph you have stated about this 11th March 24 notification or order?
Page 62.
62.
Paragraph 6.1. 6.1. That the concerned respondent by memo section 11 dated 11th March has turned down the prayer of the applicant on ASO to change her service from WPH to WPH.
You have still you have not challenged it. So what is the effect of the proviso? What is the effect of the proviso? So therefore, if one is willing to forego the increments earned in the administrative service, he or she can go back. No, that prohibition that it can be done only once is accompanied with a proviso. Therefore, that proviso, what is the meaning? What does it mean? Maybe she will be willing to forego her increments, he or she, whoever it is. Whether that is permissible, she is. Correct. That is not in dispute. That's not the point in dispute. While in 2013, option was exercised under which provision? Because this 2004 notification, whether it governs this request. So this was applicable when she had exercised option. Because you please see what this says, 2004. So this is for those who are in the West Bengal Public Health Service to exercise option. This is not under this, she has not exercised option because she has gone from health service to public administration. So this will not apply. Here, 2A, persons who hold posts connect administration unit. This is for them. You please organize this. We will have to consider. You organize this brief. File a paper book properly. All everything is haphazard. It cannot be.
And my lord, that I will do certainly too, my lord. If your lordship kindly come to page 111 of my compilation.
Do it.
That
We'll see everything.
my lord.
Yes, the readings have.
Second option. It is for the administration. Because she has come from health administration. But this cannot be helped. Maybe there is some other provision, or after going through somewhere, it must be saying in that notification that it is for both circumstances.
I am not the petitioner, my lord, in this matter. But I will file my affidavit in reply.
Item number 12.
Item 12 and 13 are, my lord, exact matter. Both the matters I appear for the respondent number 1, the private respondent.
We have placed the matter before your lordship and it was completed on behalf of the petitioner. There was that last order lordship that the respondent to advance argument.
Yes.
Respondent number 1
obtained her permanent registration certificate as an Ayurvedic practitioner by the Pongo Ayurvedic Orishad. Thereafter, he obtained another permanent registration certificate issued by Maharashtra government, which is not permissible under the law. The Ayurvedic practitioner, Ayurvedic Orishad issued a Shepherd's notice to the petitioner, which is appearing at page 35 here. Kindly Lordship says the page 35. First post show cause notice issued the respondent number 1. Ayurvedic system of medical Act 1961. In response to reference number such and such.
Last order of.
Consider the gravity of the opposite fact and making important the exercise of the Medicine Act 1961 enclosed. The above said a candidate belonging to registration number such and such is being withheld with immediate effect. The same registration number to be held on suspension from practicing or application to any regarding job, government or non-government today onward till the matter is resolved. By these candidates being informed to show cause for this illegal malafide practice immediately. Second show cause notice issued on 2nd February. Reference to letter number such and such, Dr. Ushashi Chowdhury is being instructed to inform Kochim Bongo Ayurvedic Parishad so or malafide illegal practice of dual registration with both Kochim Bongo Ayurvedic Parishad and Maharashtra Council, training that Kochim Bongo Ayurvedic Parishad will cancel the registration of such and such, applying section 24 of Kochim Bongo Ayurvedic System of Medicine 1961. No reply received. Thereafter, finally, second reminder was given. Your Lordship, that is appearing at page 37. With the reference to reminder number such and such, Dr. Ushashi Chowdhury is being strictly instructed to inform the Kochim Bongo Ayurvedic Parishad so cause her malafide illegal practice or dual registration with both Kochim Bongo Ayurvedic Parishad and Maharashtra Council. Restriction was such and such that failing that Kochim Bongo Ayurvedic Parishad cancel the registration number such as applied to the section of Kochim Bongo System of Medicine Act. Thereafter, we have not received any reply. Then we will also come to page 38. That's the next page. Annexure 36. With reference number such and such, belonging to Dr. Ushashi Chowdhury be cancelled with immediate effect as exercising section 29 of Kochim Bongo Ayurvedic System of Medicine Act 1961 and section. Thereafter, we have received Ayurvedic cancelled the registration of respondent number 1 because of having dual registration of the practicing of Ayurvedic. In meantime, on 30th December 2022, the West Bengal Health Recruitment Board published an order advertisement dated 12th February 2022 invited online application to the post of senior Ayurvedic medical officer. And respondent numbers applied for that post using this application, which was cancelled.
Cancelled?
Yes, cancelled. Just I placed before Lordship at page 38.
Where is the cancellation? What is the date of cancellation?
7/2023.
July.
23.
23.
Before
So
that,
application was made in 22.
before that, at page
So how you are saying it was cancelled? When
it was suspended. Suspended, not cancelled.
Don't say cancelled.
Suspended. Then also she applied online for the chat post, knowing fully well that her registration number has been withheld as she was put on suspension from practicing or application to any regarding job. Because in the first focus notice, it is clearly mentioned that
So this suspension is under which provision?
that is a Lordship section 29.
Yes. Please place the provisions.
Section
This we did not hear. This bench did not hear you earlier. Please.
Dear Lordship, Section 29 of Pachim Bongo Ayurvedic System of Arthritis Act 1961.
Play page.
Act is there, my lord.
Can.
No, my lord. The act
is
earlier, my lord, we have supplied the copy of acts.
So you have to place it, which provision you are relying upon. There are two matters.
Two matters, Your Lordship, analogous.
Which act?
Ayurveda Medicine Act 1961.
61 Act.
61 Act.
Page section 29.
Section 29.
No, 29 is regarding cancellation. Where is the provision for suspension?
No, no. Lord, may I address? Your Lord, with permission of my landed senior.
Yes.
Yes. Where is the provision for suspension?
Yeah, may I please, your lordship? Not so far.
For the Bongo, we suspended the, cancelled the registration number of the respondent number 1, Your Lordship.
Yes.
So far this act is concerned, 1961 Act is concerned, my lord, so far the suspension is concerned, my lord, there is no clear cut. There is a cancellation is there. But prior for cancellation, for the purpose of giving a hearing or giving a show cause, that registration is suspended for temporarily, and then my lord, she was asked to give the show cause.
So without any foundation in the act, there is no source of such power to suspend.
The power is for cancellation.
That we have seen 29.
But prior to cancel, we have to the process that is followed is that the registration is temporarily suspended, and then my lord, she was asked to to give the show cause that why, without informing anything, my lord, she has taken the dual registration. That is the my lord, I might be very much candid to your lordship that I also, my lord, address your lordship in the last occasion, and for the my lord, for purpose of appraisal of my lord Justice Vishwas, my lord, that there is absolutely no such clear cut, my lord, provision. Absolutely. That I have lastly also contended. However, this act is very old. Subsequently, the regulations came. My lord, kindly appraise what happened. My lord, my lord, for your lordship say, this petitioner got the registration in Paschim Banga Ayurveda Parishad. Now the scheme of the registration is that there is one state register board which acts in the state, and then there is a central registration board which acts in the Milord pan India. Now the registration of this each practitioner, each Ayurvedic practitioner need to first register under a state registration in order to practice and in order to do anything. After this passing of the graduation, BAMS, then they need to register under a state register, any state register. Now in India, there are certain states where there are no registration board. In that case, direct registration to CCIM is CCIM used to be done. But I am talking about prior enacting the NSICM. which is the Milord subsequent body of CCIM. CCIM thereafter Milord, it was taken over, or it was Milord transferred to NSICM in 2020 by virtue of the act. But prior to that, because this is Milord CCM Act is concerned in this matter, so CCIM used to take care of all the registration, and all the state required to upload the state registration to the central Milord data of the CCIM. Now the rule also says that once a registration is cancelled in the state registered board, then the central registration is also cancelled. Now, so far dual registration is concerned, what happened in this case, the respondent, she took the registration in Ayurved, Paschim Banga Ayurved Porishad in Milord in the year 2014 first. Then subsequently she changed her address. She left West Bengal, she went to Maharashtra. Now, my lord, kindly consider here for once, there is two different aspects. One is for practicing Ayurveda, private practicing, and one is for getting a job, service. In both the cases, this registration certificate is required. Now, so far the private practice is concerned, my lord, the rules as per the CCIM stated that she requires to register in any state register first. Any state register has to be. In the absence of any state register, the CCIM will give her or give him the direct registration. It was the earlier rule, the rule which is applicable over here. She applied in the Paschim Banga Ayurved Porishad, so she was, my lord, entitled to practice and, my lord, take job in West Bengal at that when 2014 onwards. The CCIM also says that by the 2014 notification, it came into light. I can produce, I will produce, your lordship. I'll just appraising the brief fact. CCIM also came with a notification that if a practitioner is once enrolled in a state registrar, well, kindly consider, once enrolled in state registrar, the candidate is not to be registered in any register. She or he can practice in anywhere in India. In anywhere in India. However, if there is no state register, then my lord.
Yes, then
the practitioner need to register in the Indian CCIM directly stating her residence and, my lord, practice. What happened here?
In any case, he or she can be registered with CCI.
CCIM.
Yes, CCIM. Even
Yes.
if there is a council in the state, even if there is no council in the state.
Yes.
In either case, one can register with the central council.
Absolutely.
Yes.
Right. But CCIM says, in the notification, CCIM stated that if once he is registered in the state, then that candidate need not to register in any other state, because that will be a dual register. Now, what is the purpose of? Each state registration gives the power to vote. Once a person is registered in a state register, and once another person, she or he get the registration in another state register, then she gets dual registration in a CCIM, because, my lord, each and every state is forwarding their data to the central register. That was impermissible. And that is why once a person, the notification says, once a person is registered in the state, having the state registered board, then, my lord, that candidate is not required to register in any other state. And, my lord, here, Maharashtra.
So this is issued by the Central Council.
Central Council.
Where is that?
My lord,
We'll just see that.
Yes, my lord. May it please your lordships. Not as I was arguing that there was a notification by the Central Council in 2014.
The petitioner's appointment has been cancelled.
This way. Here, my lord, what happened? She sat for examination, and subsequently, my lord, after verification of the document, since it was found that her registration was not proper, she was her name in the list was, my lord, not published.
Oh, at the before the
yes
select list was published.
Yes,
It was.
Selection, she was not selected. Final selection was not there. And my lord, before
Oh, she was amongst the recommended candidates,
she was
but post verification she was.
Yes, my lord. My lord, before I entering into this notification, may I address your lordship one point, that so far this cancellation or suspension or registration, that point or that challenge has never been made in the way. In the original application in the SAT, that she suspended, that we didn't have any power like this. This question was not arose. However, as your lordship pleases, I try to satisfy your lordship.
No, but this fact that her candidature was suspended.
Yes, my lord.
At the time she had applied or in the process, was it made known to her at the time of filing the?
That I'm going to address your lordship.
No, my lord, my contention is no.
Let us see. We are asking him. We'll come to you. Don't worry.
I will. Then, my lord, first may I place this notification? My lord. May I read, my lord? This is dated, my lord, 24th March.
Let us first get the date. So she registered with this Bengal Council when?
2nd May 2014.
And in Maharashtra?
Maharashtra, she enrolled 13th April 2022. Prior, my lord, this
the application was made in November.
Advertisement was made, my lord, on November 2022. November.
And suspension is of December.
My lord.
Suspension, what is that?
Suspension is of July.
Prior to that.
My lord, I stand corrected, my lord. I stand corrected, my lord. Just a second, my lord. Just July or November. No, suspension ta. Suspension ta হচ্ছে আপনার Okay. 21 November 2022. 21st November 2022, her application was suspended. Now, last date of submission of online application was after that, my lord. That was in December 2022.
Which December?
30th December 2022.
30.
Yes, 30.
And what is the date of the advertisement?
Advertisement date is, my lord, advertisement 12/12/2022.
12/12? No,
yes,
it is
12th December 2022.
Oh.
12th December 2022.
And final cancellation?
Final cancellation is, my lord, 14th July 2023.
14/7.
14/7/2023.
This is cancellation of her Bengal registration.
She still holding the registration of Maharashtra.
Therefore, we said
absolutely. She is still holding.
Yes. Now let us.
Now this notification is 2014. I am directed to draw your kind attention to the subject mentioned above, and to say that Central Council of Indian Medicine, by virtue of provision section 23 of Indian Medicine Council Act, is maintaining the Central Register of Indian Medicine, which contains the names of all persons enrolled on any state register of Indian Medicine and who possess any of the recognized medical qualification, included the schedules to the Indian Medicine Central Council Act 1970. Further, it is informed that the practitioners whose names are included in the Central Register of Indian Medicine and have been allotted Central Registration number by this council are entitled to practice in anywhere in India, as per provision section 29 of Indian Medicine Central Council Act, subject to continuation of a valid registration on the state register of Indian medicine of that particular state, on the basis of which their names have been included in the central register Indian medicine. Therefore, my lord, this note, there is no need for such practitioner to get a dual register in any other state. This was the notification. Now, my lord, in the next para, in this connection, it is further informed that as per provision provided under clause 5 of the CCIM regulation 1979, my lord, and as per the decision of CCIM in meeting executive committee held in 1997, the Central Council is granting direct resignation to those persons who are holder of any recognized medical qualification and residing or practicing in such states where there is no state registration. As I, my lord, appraised your lordship previously, that this is direct, where there is no state registration, that candidate can directly apply. However, if any person who has been registered by the council directly desires to start a medical practice in such state where there is a state registration board council functional, he must be registered with the respective state board council. The matter of the domicile is not corrected. So, the second condition is that once she is residing or practicing in a state where there is no register, she directly registered to the CCIM. Subsequently, she wants to practice in another state where the state register is there. Then she has to again, my lord. In this connection, it is further submitted. Now, this is the paragraph which is, my lord, I would like to draw your attention. It is further submitted. It is been brought to the notice of this council that the persons who have been registered with the CCIM directly are practicing in Maharashtra, Gujarat, and UP states, etc., whereas they had shown their residential practice address of Manipur, Jharkhand, and Andaman, Nicobar, etc., which there is no state registered bar council. Now, the next state, since the Central Council has taken the issue seriously, you are therefore requested to look into the matter and to restrain from medical practice to those persons who have directly been registered with the Central Council of Indian Medicine. Such persons may not be allowed for medical practice without getting registration from the respective state registered bar council. So, my lord, the scheme, the idea of CCIM is, it is clear that, and my lord, that is backed by the reason that can adhere the person to votes from a particular state, one state where she has previously registered, and if she wants to register dual registration another state, then she gets another voting capacity, which is not.
This is different. This says that someone who is directly registered with CCIM,
yes,
if they want to practice in a state, they must register with the state.
If they want to, my lord,
practice in the state, they must register with that state.
Yes,
that is all.
No, my lord.
If they have not registered, then you please take steps.
My lord, may I try to, my lord, point it out?
They will not be required if there is no registration council in that state.
Yes.
But if in that state there is a registration council, they must register.
They must register, provide all.
There's nothing here regarding any voting or anything.
No, I am like to submit that, my lord, the CCIM rule says that there is only one vote for a.
We don't know. Here what we have seen is only this.
Absolutely.
That we have not seen.
No, absolutely. But I just like to appraise your lordship what might be the idea behind doing this.
There's nothing here. There is nothing here which suggests even anything about any voting rights.
Absolutely, my lord.
In
But
this,
so far
in this communication addressed to all the state board registration, there is nothing of the sort.
My lord, the dual registration is not permitted. That is there.
That is not there also.
My lord, that is there, my lord.
Please see.
My lord, first paragraph.
Yes.
My lord, that if a person is registered in a state where there is a state registration, then if she wants to start practice in another state where there is a state registered board, my lord, she need not to, or he cannot.
Need not.
Yeah, now, my lord.
It says need not. It does not say that there is a bar.
I bow down to your lord.
Yes.
Now, this is the absolutely, my lord. I also have to, my lord, address to that point that need not and, my lord, bar. There is whether it is absolutely barred or not, my lord. So far, this is concerned. I must be candid that this part, that CCIM regulation till that date was not amended. So this thing that this is barred, that was not been in the regulation, was not there. Subsequently, just to appraise your lordship, subsequently when the regulation came of NSICM, that came in just December 2023, which came into effect. There, my lord.
So prior to December 23, there is no bar.
That is what I'm saying, my lord. That is what I'm saying, my lord. I am not going to take anything away.
Where is the December 23
2023, which is not applicable over here, I am submitting, your lordship. Which is not applicable because her cancellation was done prior to that, and my lord, 2023 came after.
You have cancelled in July.
Yes.
And that regulation has come into
Yes,
force.
that is right. That is absolutely right. But what I'm saying, that what prompted the legislator to, my lord, bar the dual registration, this is the 2014 that came into the scheme. My lord, to my humble estimation, subject to correction, that, my lord, no statute, no contract, my lord, are, my lord, exclusive, and everything could be, my lord, everything is complete. Every statute there is an incompleteness. And here, my lord, your lordship, I beseech your lordship to visualize the idea. CCIM is already, my lord, barring, or, my lord, trying to bar dual registration, which came into effect in 2023. Be that as it may. Be that as it may, my lord. Now the another part is, my lord, what I, my lord, pointed out, that her, if the my lord, act is very much clear, had she any kind of difficulties with this, my lord, cancellation, suppose I do not have any power, then there was a provision of appeal. Section 30, my lord, kindly sees the act, my lord.
Yes, it is in 30, an appeal shall lie to the state
Yes,
government.
my lord.
Yes.
She also did not apply for that. Now the question would arise that, was she communicated? Was she communicated? Was she, my lord, knew about the registration, cancellation of the suspension of this? To that effect, my lord, my learned senior has already, my lord, pointed out that 2 reminders were given, were supplied to her, and my lord,
No, we have not seen. See, you are addressing this bench for the first time.
No, my lord, prior my starting, my lord, I think my learned senior has pointed out 2 reminders. I am placing.
Yes.
I stand corrected. I am placing, my lord. First reminder, lord, kindly come to page 170.
Which brief?
My lord, my WP 81, my lord.
That is the first one.
Yes, my lord, first.
Page, please.
No, my lord, the 81 is the number 13. Today's list, it is appearing. Or 81 is earlier. There are 1 this.
No, so we are referring to which?
81, my lord. WPST 81, page 170.
170?
Yes, my lord. Prior to that, my lord, for once, kindly come to 169. That, my lord, the suspension order, my lord, what we have absolutely categorically stated in the last but in paragraph, there is said registration number to be held on suspension from practicing or application of any regarding job. That is already mentioned, that she is barred from practicing and applying for job. Now I understand, my lord, whether it is rightly or wrongly done. Now in page number 170, your lordship will find that we have communicated this to the respondent. This was the first reminder. With reference to such and such, it is being strictly instructed to inform. Dr. Usha Chaudhary is being strictly instructed to inform Paschim Banga show cause. But we have given her opportunity. It is not that we are directly cancelled. We just directly cancelled. We did not this. We did not do. We send her a notice, asked her to show cause. Then and again we have sent a second reminder in the page 171. Second reminder, that is 24th March 2023. It is not that we have just directly cancelled without giving her any opportunity to, my lord, say anything. Now the question would arise. Now after that, my lord, on 172 on 14th July we cancelled. My lord, got it? We cancelled thereafter.
No,
only
how you came to know about the registration with Maharashtra?
That was, my lord, communicated in our with a complaint, my lord.
So please, you read your opening line of page 169.
Yes, my lord.
In response to. What is that?
এটাই কি ছিল আপনার এমসিএম রেজিস্টারিং এটা ডেট মার্চ 2022 এটা কি ছিল
You are referring to several communications.
Actually, no, সেটা না, সেটা না।
What prompted you?
My lord, I fail to understand your lordship's query that how we came to know that she.
Yes, what prompted you to issue a notice?
Very good, very
There was some complaint made by someone. What are these letters which you are referring to? There is one of 3rd March 22. Then there is one of 22nd February 22. Then there is a 28th January 22. There are 3 letters referred to. What are these 3 letters?
My lord.
In response to reference number so and so.
Yes, that is
3322, 22 to 22, 28 122. What are these?
my lord, I am addressing, my lord. Give me some time, my lord. এটা বের করুন, এটা বের করে my lord, we will be addressing, my lord, in this on this point, my lord. Definitely we will be addressing this point. However, my lord, for this time being, my lord, for consider that whether we have communicated to her.
So all right, you say we have sent 3, we have sent 1 page 169, we have sent page 170, we have sent 171, and after 3 notices and reminders by page 172, 14/7/23, you have cancelled.
Yes. Now, my lord, another thing, what my learned senior last day stated that no, these reminders were not served.
Forget, let
May
him
I
say
address
what
on that point?
he will address when he has to address.
We have this.
First, tell us why this action was initiated.
There was, as per my
Because you are referring to 3 communications. What are these 3 communications?
no, may I say, there was a draft rule to that extent that in that rule, prior coming in the NSICM, a draft rule came into light. But I have been informed. Well, on instruction, I'm submitting. My lord, page number 169, right? Just a second. There was a complaint on the basis of
date of complaint.
Date of complaint is 17th October 2022.
That is not referred to in this letter.
No.
There is a reference.
One of the practitioner.
3 communications have been referred, one of January 22, one of February 22, and one of March 22.
By name has been enjoying under this council from Maharashtra Council. The gravity of the
interesting, my registration is of April 2022. So these 3 letters, my registration with Maharashtra Parishad is of April 2022. So these 3 letters cannot be the issue, my lord.
Which one?
Is something is my lord, not
no, this is not letter. This is not the letter. These 3 are memo, my lord.
This memo, my lord.
These are not the letter. One complaint came.
What are these 3 documents? You tell us. What prompted you to take up this issue?
My lord, draft rule
MCIM is the national
CCIM.
No, what is MCIM?
CCIM is no more in existence.
Yes.
Or NSI, National School of Indian Council of Medicine is in course, my lord.
National school?
No, national school not.
National
Not
Standard
national.
of just a minute.
National standard.
National Commission of Indian.
Yes, NC. That has been, my lord, taken over by CCIM. Been taken over. Is no more existing.
From 2020 onwards.
This was a draft rule, my lord, as a
National Council
of Indian Standard of Medicine. Indian System of Medicine. National Commission of Indian System of Medicine. National Commission of Indian System of Medicine. It came into light in 2020 by virtue of that act. Now the problem is that there was no regulation. The regulation came only after 2023. And the act, there was a provision which says that despite there is an act, but all the regulations will follow the earlier CCIM Act regulation.
So all right, then you have, it is your case, you have given a notice and thereafter you have cancelled.
Thereafter we have cancelled. And my lord, what she did then? My lord, in the application, why we cancelled? In the application, if your lordship sees the application, then your lordship will find it was categorically mentioned that a candidate need to be registered in Paschim Banga Ayurved Parishad or my lord?
That is not your concern. Your concern is only this certificate.
Yes,
Beyond that, you have nothing to do.
yes, my lord. We were given the duty to, my lord, verify the document.
Only that.
Yes.
Forget about what is there in the advertisement. That is not your concern. You are there only to disable her from participating. Beyond that, what happens, that is not your concern.
So I am not here to, my lord, disable anybody, my lord.
No, you are. You say you are required to disable someone who has gone for a dual registration. Then they cannot be allowed to either practice and they also cannot be allowed to get into an employment.
Yes,
So you have to disable. How you will disable? By cancelling the certificate.
to restrain a person, right? That is right.
Correct.
Absolutely right.
Correct.
Provided now, my lord, why her candidature was cancelled?
We are not on that. We don't want to. You will not address us on that. For that, they will address us. Your concern is only the registration aspect.
Yes.
You have not been able to show why you issued these notices.
No,
What is the basis? We have asked you. You have not been able to.
Then, my lord, kindly give me one day.
What is this?
Because this part.
What this part you are referring to this?
I
It is your document. It is not their document.
I told your lordship, and I am again submitting that there was no categorical rule barring the dual registration.
We are
But
not on that.
virtue of
We are
notification
not on that. We are saying your action is prompted by 3 communications. One communication of January 22, one of February 22, and one of March 22. 3 communications coming in 3 successive months.
Yes, my lord.
You say because of this we are initiating this, we are serving this notice. What is that? You don't specify in this letter. What is that? You don't tell the court.
My lord, then, my lord, I frankly speaking, I am, my lord, short of that.
Yes.
Short of this
you
information
don't have
as
it.
on today. As on today.
Now, please try to understand why we are making this query.
Right.
You know that she is registered in Maharashtra.
Yes.
This is apparent from page 169.
Yes.
And where have you sent this notice? Please read the address.
She is having her address, another address, because my lord,
So therefore, knowing that she has registered in Maharashtra, you know that now she is practicing in Maharashtra. You are sending 3 notices to address in Bengal, and on that basis you are saying no response, we are cancelling.
because her address.
So therefore, mere issuance of notice is sufficient, or actual proof of service is required with before such a penal measure can be taken.
Absolutely right. I bow
That
down.
is the law.
Absolutely. Now, so the next part comes that
Yes.
whether she was rightly communicated. She
Yes.
knew that. Now, my lord, may I address on that point?
Yes.
That whether she knew that.
Yes.
Now, prior to that, my lord, I need to also, my lord, clarify that the rule is that once she changes her address,
forget about it.
For my side, kindly. my lord.
Yes.
Once she changes her address, she needs to inform the.
She may have committed a whole lot of mistakes. The point is, you are required to ensure service. How you say that service was ensured? Show us.
I'm showing.
Yes.
Only one thing, my lord. But before that, kindly appreciate one thing. That, my lord, I am only having the information that she is registered.
We don't know. Therefore, we are saying there are 3 letters sent to you. What is written in those 3 letters?
Absolutely.
Whether her address from Maharashtra is given, where she is practicing in Maharashtra, whether she has taken up employment. We don't know.
In the letter itself, it says that I am aware of the fact that she is registered in Maharashtra.
That the letter says, but the letter does not disclose what all information is in these 3 letters.
My lord, am I supposed to know that what are present address in Maharashtra?
You are supposed to know.
Yes.
You
Now,
are supposed to.
Yes, absolutely, my lord. May I address?
Yes.
On that point, the rule is clear. If she changes her address, she needs to communicate it to the Ayurved Parishad.
That you have said. You have said. You need not repeat the same thing.
Had she communicated to us? So
Therefore, she has not communicated. You don't know her address. Therefore, you will send wherever you want and you say it is served. So ultimately, you have to show that it has been served. Forget about what she has done.
But the address.
How do you show where it has been served? Just show us.
I will. The address which was with us.
Forget it.
This is the address.
Where is the
Now,
service? Proof of service. Show us. Merely showing that, saying that this is the address. Therefore,
yes,
it cannot be deemed to be served.
Absolutely. Now, my lord, for that reason, there are official.
Where is the service?
My lord, the official services are communicated through post, my lord. Through post. These are
Is
the
there any proof of service? We are asking you for the nth time.
if I say
She may have committed whole lot of blunders. She may have kept her address secret.
Hmm.
You are proposing to take a penal action. What steps have you taken to ensure that she has received the notice? We are asking you only this. It is a penal action. You are depriving her of her qualification.
Right.
So therefore, there must be actual service.
If she
Mere issuance of a notice does not mean that it has been served. Law is very well settled.
If I may show your lordship, I'm saying postal receipts are not kept in this way in the office. The diaries are maintained. This is official evidence.
Nothing is there on record.
No,
Don't hand over such documents.
No, Milord, there is one thing. It is the admission on her part. It is an
So
admission.
there is no proof. You are relying on an admission.
Then, Milord, how?
Very well. Show us the admission.
Milord, that she knew.
Please show us. Merely by saying it is in your head, therefore
I am not going to say
show
anything.
us.
But yes, Milord, absolutely, this is right. That not every word is there, but it
No,
is
no, just show us that there is some admission in any document anywhere that she is aware in November 22 when she is applying that her certificate is on.
Her admission is not at that time. Her admission came later when she wanted to re-register.
Then why are you raising this issue?
Because
Then why are you
that
raising
says
such
that
irrelevant?
She was communicated. She knew the fact.
Irrelevant.
That
So
thing-
let us see.
Kindly come
Let
to
us.
page 184. I am
Yes.
going to
Let us see. Let us see. Just
But
show the
see-
document. Don't make submission.
No, I am
First show the
Yes,
document, then make submission.
184. First 184. When she wanted, this is 9th January
24.
Yes.
Much later.
Yes, much later. Of course, much later.
Yes.
Of course, much later. What she says.
This is after she has been excluded from the recruitment process.
That is what I'm saying. I'm not denying.
Then,
but that her knowledge, the previous cancellation was there.
Let's read. Where does it say?
Yes, my lord. May I say? What she says, most humbly and respectfully, I beg to state that I, Dr. Ushoshi Ghosh Chaudhary, have been selected as per SAMO under such and such. I was previously registered under Paschim Bongo Ayurved Parishad, who renewed for the year December 2023. But due to financial issues, I have to move Maharashtra for the job purpose in the year 2022. As at that time CCIM was dissolved, therefore I was unable to get central registration. And as per law, I had to take state registration of Maharashtra. She stated, due to some personal reason, I was unable to take NOC from West Bengal. She knew that she was doing this. She's saying that now.
That's not the point. The point is whether notice was served. You are making unnecessary submissions repeatedly.
It is about the knowledge.
She knows she has gone and registered. She doesn't know.
If she knows that she got.
Therefore, you can proceed to do whatever you want.
Not I'm saying that.
So show us the service or admission.
In our
unnecessary submission.
There is no such kind of postal.
So there is no service. There is no admission.
Your lordship can say that.
But no, you may show. Either you show or you
show that.
You cannot.
What I can show you that she had the knowledge.
You cannot deny that you are obliged to serve a notice. Can you say that without notice you can proceed?
Absolutely not.
Then,
absolutely right.
Then the basic thing you are required to show is whether notice was served or not.
What my lord is asking.
You said notice was not served, but that is implied because she has admitted. Where is the admission? All these submissions are without the facts.
We come to the next letters also.
Yes.
There are 3 letters.
Just show us in which letter there is the admission. Why we should see 10 letters? Show us where is the admission. You are making out a case without the facts. And if the fact is there, just show it in which document it is. You need not read the entire brief here.
Kindly come to 186 page.
Yes.
I, Dr. Ushoshi Ghosh Chaudhary, submitting my registration certificates and ID card, which were given by Paschim Bongo Ayurved Parishad age to pay punishment, registration, cancellation charges, and as per 14th July 2023 notice. Now, if it is not, then my lord, I have nothing to say.
Page 186.
Then I have nothing to say, my lord. I
Very
do
good.
not have anything to prove that that postal receipt is required. I mean, they have maintained. It is not that. She wanted to take benefit of everything from West Bengal as well as Maharashtra. She has obtained the job in Maharashtra without suspending the certificate.
You are a statutory body.
My lord.
you are bound to proceed in accordance with law.
Absolutely.
If she has committed 10 mistakes,
Absolutely.
that will not enable you to go amok and do whatever you want. You will still be guided by the procedural safeguards. She may be the worst person, but you have to be overboard in everything you do.
Absolutely. She also required to challenge it.
That is a different thing. Don't
Did
jump
not
from
challenge.
one point to the other. We are on the issuance of a notice and
My
service of.
job is, my lord, as per this is my case.
All right. So
I have
186, you have already said. 186, we have seen.
I have nothing, my lord, anything else to this kind of private grudge to a person.
Therefore, we are saying.
That is absolutely right.
Cannot be.
Absolutely right.
Cannot.
We have followed this kind of rules and regulations.
So therefore,
That
your
was there.
case
This is-
hinges on this notice of 19 January 24.
19 January 24, it is not notice. It is she applying to us.
Her letter.
Her
letter. Yes.
That 14th July notice.
Yes,
is there.
yes. All right. Anything else?
So far, if your lordship, now let me address on that point that I mean, your lordship may hear it from my learned senior also, but no, he is there.
Yes.
So far, her conduct in applying, whether she was permitted to do that. If your lordship ask me, I can, but otherwise, my lord.
No, that is not your concern. That is not your concern.
Then, my lord, I reserve my.
Your concern is only with regard to whether dual registration she could have continued. If she has continued, whether you had the jurisdiction to suspend it. Even if you had the jurisdiction, did you suspend it with due notice? Was the cancellation preceded by a notice? If not, what is the effect of cancellation?
Absolutely.
That's
Right.
over. Yes.
Only one thing, my lord, may I reserve the right to reply?
Yes, you obviously you
This
will.
much.
Yes.
So I have nothing left to add.
Yes. Let's see. Hmm.
My lord, only cancellation ta kena korle seta to bolte. Why you force? What she has done, she to a registration na bodle a registration take must say this.
My cancellation than the state.
Sorry.
Seems like, my lord.
Sorry.
My lord, your lordship takes up 19th January notice. Got this letter issued by me. It says, my lord, for re-registration of my registration with Paschim Bongo Porishad.
We are referring to which document?
86 months just now, my lord, it's sure.
Yes.
I, Dr. Bushu, is submitting the registration certificates and ID card, which were given to my Paschim Bongo Ayurvedic Porishad, and agreed to pay a punishment registration cancellation, which is the punishment of 5,000. I paid it. For charges and as per 14,700 notice. Got it, my lord? I came to know about this cancellation only when I was called in for my verifications. The lordship takes up page 52 once. The dates are important, my lord. What my learned friend is saying is not the truth. I may say, subject lordship kind consideration. Well, page 52, your lordship kindly comes. Well, page 52, my lord, is the verification schedule. Was given by the, my lord, the recruitment board, wherein I was asked to produce my lord, the academic qualifications and the registration certificate. Porishad was there. Your lordship will take note at the bottom, copy forwarded for information to the registrar Paschim Bongo Ayurvedic Porishad.
Page 52.
52, my lord. This is the schedule, my lord. If your lordship may got it, my lord. I'm referring to WPSC 81.
Page 52 is
52, my lord. Sorry, my lord. 89. I'm extremely sorry, my lord.
89.
'89.
Sorry, lordship will find it says the verification schedule for candidates who have been recommended by the West Bengal Health Recruitment Board for recruitment to the post of Senior Ayurvedic Medical Officer under the Department of Health and Family Welfare is mentioned below. Now, my lord, the date is date of document verification 16/1. My lord, thereafter, second floor, and my lord, reporting time such and such. My lord, what I have to bring, those were there. And my lord, at the bottom, your lordship will find copy forwarded for information necessary action 2. My lord, 1 may not be important 2. Registrar Paschim Bongo Ayurvedic Porishad Purtobon Sector 2 Salt Lake Kolkata 64 with request to depute personnel on behalf of his office for verification of academic qualification and registration certificate. of the candidates on the date of document verification at the above mentioned venue. So, my lord, on 16th, when I went, this is later dated 4th of January. On 16th, I went there. There I came to know my registration has been cancelled. And my lord, with regard to what my learned friend has said, those notices, my lord, those were never served to me. This is instruction from my client. Not only that, my lord, if your lordship takes up those notices, I may say the purported, my lord, notices issued with regard to suspension is concerned, my lord, if your lordship takes up page 130, 168, 69, my lord, once. So, my lord, after knowing about my cancellation, my lord, I approached them on 19th of January. But be that as it may, my lord, kindly takes up 169. My lord, your lordship has pointed out with reference to memo number such and such dated 3rd March 2022, memo number such and such dated 22nd February 2022, and memo number such and such dated 20th January 2022, one candidate, namely Sri Dr. Ushasri Ghosh Chaudhary, belonging to registration number such and such dated such and such, has been enjoying dual registration number such and such under the council under registration number such and such, from Maharashtra Council of Medicine since 13/4/2022. So, my lord, I was enrolled with Maharashtra in the month of April. These 3 memos were issued prior to that. So, my lord, whether I will be enrolled in Maharashtra on 13/4 or I may not be enrolled with the Maharashtra, that means the situation. Beforehand, they came to know I will be getting registration. Or your lordship will find 3 memos were there. All were dated March 22, 2022.
January, February, and March 22.
And I
Yes.
got registration in April 2022. But beforehand, how they could know even that I'm going to get registered in Maharashtra?
Yes, that registration date they have mentioned.
Yes, my lord.
13/4/22.
So, my lord, these 3 memos are not the reasons. My lord, reasons may be something else which is not meeting the eye.
In the very same letter, they have given the date 13/4/22.
Yes, my lord. So, my lord, these are not the issue, my lord. There is something which is not meeting the eye, I may say. Not the further, I may say, my lord, let them show a scrap of document. I asked my client time and again whether these notices were ever served upon you. He categorically said, my lord, it's not been served. My lord, let them show a piece of document, a postal receipt, where trackings are there. Well, it's a government office, they must be having that.
No, they said he has candidly said there is no such material.
It was never served, my lord. This is my humble contention before your lordship. Not only that, my lord, if your lordship allows me to say, my lord, one document is there that I have been enrolled with the national, my lord, that is, my lord, I'm just coming, my lord. Please come to page 164. Now, my lord, your lordship has seen the mark in the, my lord, the purported suspension letter which was there. My lord, it's dated, my lord, 22nd of November 2022.
21st November.
21st November. Now, my lord, if your lordship takes up page 164, my lord, this is the Board of Ethics and Registration of Indian System of Medicine. Now, my lord, normally, my lord, with regard to this, my lord, National Board, National Council, whatever it is there, my lord, names are to be sent by the, my lord, the state boards for registration with NSICM. Now, my lord, this is the, my lord, a compilation. If your lordship takes up page 165, your lordship will find my name. 165 at the last, my lord, at the bottom. 1700 is the serial number. But thereafter NRAY, but this is my registration number. My name is there. My home address is there, my lord. Thereafter, your lordship will find who has sent it. Ayurveda, BAMS, West Bengal. This is my certificate. And my lord, last column, 1229-25-2004, Paschim Bongo Ayurvedic Porishad, Kolkata. Well, they have sent this to the authorities. If your lordship takes up the earlier page, my lord, page 164, that at the last column, registration, particular registration number, date of registration, names of registrar, national state, whether registration is renewable or permanent. My lord, these were sent by the same board. Now, when I'm putting this question to myself, my lord, the advertisement speaks of either I have to be registered myself with the state board in part A or the CCM, which was non-existent from 2020. So, my lord, CCM has been, my lord, overtaken by new National Commission of National System of Indian Council Medicine. So, my lord, it has been taken over by them. I got the registration there. which was done by purportedly by them, by the Paschim Banga Ayurvedic Parishad, not by the Maharashtra board. So these being the situation, and there is nothing to show that those registration certificates, those the suspension letters and the reminders there too, first and second reminders, ever been communicated to me. It's beyond my imagination, that my registration has been cancelled. So when I went to upload the form, before 30th of December 2022, I have one option, is either I have to upload this with Paschim Banga Ayurvedic Parishad, or I have to upload it with the CCIM. Well, CCIM is not in existence then. I got NSISM by that time.
So what did you, why you have shown 164? What do you want to show from this?
164. I'm just coming around.
What is the date of this document?
I'm coming around. I did a mail to the president of this present NSISM.
NCISM.
NCISM, in response to the mail, he has clarified. I have the bail copy of it. I also applied a certificate application for RTI to show, whether I was registered prior to the date of application, filling up the application is concerned. This is the mail which I sent to the president. Beresim, is the president of the NSISM. He says,
no, why you are showing page 164?
This is a document from where I can say, I'm been registered with the National Council. CCIM is no more in existence after 2020. The advertisement says either I have to get registered with the Paschim Banga Parishad or the CCIM. CCIM is no more in existence from 2022. They know it. Both the advertisement and the Parishad knows it. Parishad also knows that I was registered with the NSISM. But they have not taken consideration of this, and straight away cancelled my candidature.
Still the question.
I will be
How is this relevant?
I will be banking on that part.
You are neither relying in the recruitment process on the registration with NCISM, nor you are relying in the recruitment process with the registration in Maharashtra. You are relying on the registration made in Bengal. So this has nothing to do.
I be there as if your lordship has fallen, my lord. I may to say, my lord, if your lordship allows me to say, as the suspension orders and the reminders was not even received by me. I was not in the know-how, and my lord, your lordship will find the last date of filing the application was 30th of December 2022. My lord, till that day, I didn't know that my registration was suspended or reminders were sent.
That is one aspect of the matter. The other aspect of the matter is, did you know that there could be no two dual registration? And if there was a dual registration, were you allowed or eligible to rely on any one registration as per convenience or as per requirement? That is we are seeing your bona fides. Forget about their action we have seen. You are a doctor. You know that you can be registered only in one place. And you know that the recruitment process is based on a registration in that place. You have consciously abandoned that and got a registration done in another place. Now at the time of recruitment, can you rely on this, knowing that you have a dual registration? The fact that you have a dual registration, is it in dispute?
No, my lord. I am not disputing that. I was registered with Paschim Banga. I thereafter went to Maharashtra.
Then you have created this mess for yourself.
I say, my lord, yes, some things there wrong by my part. I'm not disputing this part. But my lord, I also will be seeking, my lord, this, my lord, unless I am in know-how of that cancellation, my lord, I may not be. I understand.
Now the advertisement. So these are the facts which are now very clear. Now let us see the advertisement.
The advertisement is
how strict is the requirement of registration in the state, and what is the consequence of not having a registration in the state?
Right, starts from, my lord, page.
Now you have to address.
Page.
Who is appearing for the state?
One matter, Purushoth matter, Mr. Mukherjee is appearing, and the other matter, state has preferred having Mr. Yusuf was appearing, my lord. You lordship may recall, initially when Purushoth took the matter, my lord, you lordship said you don't have any locus to move this application. But thereafter, my lord, within few days, state comes in.
Anyway, that is over now. Yes.
Well, this is the page 51 is the advertisement. My lord, your lordship will find page 52. But page 52 deals with the registration part. My lord, Middle portion, your lordship will find note.
Note.
Yes, my lord. Candidate must be registered either in Part A of the State Register of Ayurvedic Medical Practitioner maintained by the Paschim Banga Ayurvedic Porishad, or in Part 1 of Central Register maintained by the Central Council of Indian Medicine. Well, these are the requirements. Now, my lord, it also says, my lord, I must be candid to your lordship, my lord, it says that if there is any...
So which of these two registrations you fulfill? You are relying on the earlier part. State Registrar of Ayurvedic Medical Practitioner.
Yes, sir. I was there with the State Ayurvedic Medical Practitioner Part 1, and my lord, Central Register by that time, my lord, CCIM is no more in existence. On the contrary, my lord, now there are...
Whether existence or not, you did not have a registration.
Yes, sir, I don't have a registration with CCIM. I had registration with the latter one which came into existence, my lord.
NCIS.
Which came later on, my lord, prior to this advertisement. Much prior to this advertisement in 2020.
Yes. Must be registered. So this is a must.
Must be registered, it says. And my lord, my cancellation took place, my lord, after the register, my lord, the applications were over. I mean, my lord, my cancellation took place, cancellation, my lord, per se, in terms of this rule, section 29 of the Act, but that came into effect on 14th of July 2023, much later of this, my lord, applying to the advertisement.
Page 55 is also important.
Page 55 says, well, registered either in Part A of the State Register of Ayurvedic Medical Practitioner maintained by the Paschim Banga Ayurvedic Porishad, or in Part 1 of the Central Register maintained by the Central Council of Indian Medicine. The candidate must be registered on or before the last date of submission of the application, either in Part A of the State Register of Ayurvedic Medical Practitioner maintained by Paschim Banga Ayurvedic Porishad, or in Part 1 of the Central Register maintained by the Central Council of Indian Medicine, and should be filled up in specified space provided in the same. Candidate, thereafter it may not be that important. It says candidates are requested to input 100 marks. That is not important with regard to marks part is there.
No, because if you are registered, you will get the full marks.
Yes, my lord. It says, if I'm registered, I will get the full marks. My lord, and your lordship can have just one look, my lord. I have just missed that thing. Lordship takes up page 51 once, my lord. I'm just, again, you, my lord.
Yes.
Page 51 says, the very second line, only online registration and submission of applications will be allowed on the website, such and such, between 16/12/2022, 10 a.m. to 30/12/2022. So, my lord, till 30/12/2022 is the date by which I have to make the applications. My lord, undisputed fact remains, be that whether it's been served or not, the fact remains, my lord, my registration was cancelled. My lord, sometime in 14th of July 2023. So, my lord, till that time, my lord, I didn't know about this, my lord, the suspension part. Till that time, even, my lord, my registration was valid with Paschim Banga Ayurvedic Porishad. Good, bad, immaterial, my lord, I may not be saying on that, my lord. But that registration was valid till that date. It cannot have a retrospectivity attached to that, my lord. So, my issue would again comes down to this, my lord, whether those were served upon me.
Yes.
And when section 29, if your lordship kindly allows me to say, my lord, it doesn't say for any provision of sending letters for suspension and reminders thereafter, my lord. It clearly says only any entry in the register which is provided, register which is provided to the satisfaction of the Porishad to have
proved, not provided. Proved, not provided.
Proved, my lord, proved. An entry in register which is proved to the satisfaction of the Porishad to have been fraudulently or incorrectly made. But where is the fraudulent or incorrect part on my part, my lord? At least for getting a registration with Paschim Bengal.
Consequence of dual registration, what is the consequence of dual registration?
That is not clear from this rule.
That is not clear.
That is not clear.
We'll see what they have to say in reply. So therefore, according to you, you did not know anything about cancellation and therefore you relied.
Cancellation took place in 14th of July, much prior to this, after this, replying to the advertisement. And I only came to know on 16th of January, per se, I may subject to kindly.
Yes, that you have said 16/1/24, page 89 you have shown.
Yes, sir. That is the day I came to know, madam.
Yes. So there is no, you did not know that there is any consequence of dual registration.
Nothing is coming out from the act itself. Only said it can be cancelled. What will be the consequence of dual registration? At that point of time, most likely, I do not know. my lord.
And was there any obligation cast on you to intimate them when you had shifted your place of practice from Bengal to?
Yes, sir, that is what they are saying, my lord. It's, even the rule says.
No, forget about what they say.
Yes, sir,
That is something, it is either there in the rule regulation or not there.
it's there in the act. my lord.
In which provision?
Section 28 হলো change of address rule 26 CCIM বা section 24 পশ্চিমবঙ্গ আয়ুর্বেদ পরিষদ
But it says 26, no?
section 24 তুমি পশ্চিমবঙ্গ আয়ুর্বেদ পরিষদ
Yes, my lord, of the act, of the 61 act, 1961 act.
and it is also mentioned in the certificate itself.
Now, every person who desires to have his name entered in the register shall submit the register an application in the prescribed form stating the particulars of his qualification period for which কোথায়?
No, rule. Just
Anyway, let's see if they are able to show.
আচ্ছা
24 does not.
24 doesn't say, my lord.
Does not.
There is rule টা তো CCIM না 22 এর rule টা
Well, your lordship takes up 33 once, my lord. Rule 33 says something, my lord. If any registered practitioner whose name has been removed from the register under subsection.
No, that is a different circumstance.
Yes, my lord. Section 25 follow করুন. Convicted, no, it's not. It's in a separate context altogether, my lord.
That's a different circumstance altogether.
Context.
দূর এটা
কোথায় তোমায় বললে যে বারবার কিছু কোথায় আছে?
আরে দাঁড়ানো আমার ফাইলটা তো Ethics rule 26, my lord. My lord, we have served the. May I address, my lord? The rule, practitioners of Indian medicine standard professional conduct etiquette rule 1982. My lord, we have supplied last day, but if your lordship so desires, this is the rule 26.
What is the name?
My lord, rule name is practitioners of Indian medicine standard of professional.
82 regulation.
1982 regulation.
Which provision?
26.
26.
Regulation 26, Code of Ethics, in part 4. A notice of change of address shall be intimated by every practitioner of Indian medicine to the concerned state board or the council and the control council. The practitioner may issue formal announcement in the press note, insertion in one or more papers regarding the following, stating on starting practice, on change of type of practice, change of address, on temporary absence from duty, on resumption of practice, on succeeding to another practice.
Lordship got the rule.
It also never says, my lord, what will be the consequence they have to follow.
This is a obligation to change the address of place of practice, not in the event, not necessarily in the event of registration in another state.
No, my lord.
Every change of place of practice has to be intimated.
And what is the consequence thereof? That is also, my lord.
A notice of change of address shall be. It does not say only if it is to, if there is a requirement of registering in another state, it has to be done. It is not linked with the registration. It says the place of practice has to be intimated.
No, আমাকে তো জিজ্ঞেস করেনি, আমাকে জিজ্ঞেস করেনি।
My learned friend is more equipped with this. No, this thing, my lord. He has got an entourage of person assisting him. He might be better positioned to, my lord, enlighten your lordship with regard to this provision.
I have to find it out myself only.
Whatever will be showed. Secretary, I mean, registrar is himself here. He must be knowing it.
That is
He is the registrar of the Parishad. He must be knowing the
yes,
laws.
yes. I can address your lordship. For registration itself, the register address is required.
So that is your case. We'll hear your reply. Come back.
My lord, today only.
Yes.
Let the state submit if they have,
Yes.
that point why they cancel, my lord, then thereafter.
Is there any order cancelling is the candidature? 96. So this is brought out by you. Now at the time of recruitment process means what date was the advertisement? So on which date in between this date when the certificate was cancelled? Cancellation date is 14/7/23. What is the date of verification of documents? Sixteen 1/24. Yes, what you were saying?
Assume for a moment that suspension order or the cancellation order was bad because according to my judgment that this was not served upon him and he's not aware of that. If he accepted, if it is accepted, then the dual registration is there, Maharashtra and West Bengal, and dual registration is prohibited.
There is a prohibition.
Prohibition. Kindly see for a moment. Page 136, clause 12 of it's called the notification issued by the National Commission for Indian System of Medicine, Ethics and Regulation 2023.
Yes, we have that.
Yes, 2023. Clause 12. No practitioner shall be allowed to enter his name in the state register if his name is already entered in another state register, notwithstanding contained in sub Regulation 1. A practitioner may obtain temporary registration certificate from one state to along with the permanent registration instead, provided that such temporary.
Just a minute. This regulation, ethics and registration regulation, has it replaced the earlier ethics regulation of 82?
Yes.
Of 82? Then we need not refer to 82.
No, what I contended.
Why we are referring to 82 when this has come into force in 2020?
This came into force in December 2023.
Yes, much before anything.
Much before, not Miller, the cancellation was done prior to this.
Prior to 2020.
Yes, 2023, this act came, this regulation came in force. Cancellation is in July.
Oh.
But however,
What is the date of notification of this? 2020.
Notification, can you see the page 133?
Date of
This
notification.
shall come into force on the date in the publication in the official gazette.
That is why we are saying where is the date? That is a settled law. That date of notification will be the date. Unless it is notified in the gazette, how it can be?
Official gazette. It is settled.
it came into force 28th December. Online copy I have. 28th December 2023. Yes. 28th December 2023. এটা আছে লেখা তো
Published in the gazette.
Yes. A gazette copy is there, page 133.
But this gazette copy does not have the date of publication. Yes, 28/12/23.
However, my lord, one line, just add. This act came before the verification document started.
The date of verification, he was ineligible.
So we need not refer to the earlier ethics. This is the rule which will apply. Yes. So under this, you are saying that there was a bar.
Bar.
In which provision?
12. 12, page 136.
And what is the consequence for violation of Rule 12, this Regulation 12?
Is a misconduct.
So there is no system for application specified in 82 regulation. Under the 82 regulation, is there any procedure prescribed for registration?
Registration, no,
Yes.
so far the registration process is concerned, that is in the act. And that is, the rule 1982 is regarding the professional etiquette and ethics.
So in the act, where is the procedure for application?
Application for registration.
Yes.
Okay, এটা দাও তো দেখি। CCIM rule 82 তো দিলাম তো। 1970 টা দিন না মাত্র। এই 82 এখানে দাদা আমার লাগবে এখানে। কি আছে বলো তো, কোনটা আছে? না না, এটা তো এইটা, এটা তো এইটাতে আছে। একটা দেখো তো। আছে My lord, CCIM Act, Section 25. CCIM 1970 Act, my lord.
So there is no procedure
Procedure for
registration on being satisfied. Under section 25, it says on being satisfied.
the state can, there are two kinds of registration, the state and directly to the CCIM. My lord, yes, sorry.
Where is the procedure for application before the state council?
My lord, so far application to the state council. This is the
Section 25, section 25 of the 61 Act you are referring to.
Right.
It does not specify any procedure.
Procedure. My lord, that is in
You
the
said it
Act.
is there in the Act. It is not there in the Act. Act says on being satisfied it can be.
There is a state registration in the Act of the Paschim Banga Ayurveda Register.
Huh?
Paschim Banga Ayurveda Porishad System Act.
Where is it?
1961.
Where is it?
Section
In which provision?
Section 24, my lord.
Of
the Paschim Banga Ayurveda Porishad Act, 1961.
22.
24. 24. 25.
In the prescribed form, where is the form?
No, section 24, my lord.
Sir, please read 20.
My lord. Every person who desires to have his name, acha, in the prescribed form.
Where is the prescribed form?
Stating particular, that is in the schedule, I guess. কোথায় গেল দেখি দাদা, তুমি যেটা দিলে। এটা তো CCI আপনি এই যে এইটার ফর্মটা কি ফর্ম? We have form, there is a form which, by virtue of which, my lord, the applications are made to the state registrar. As per the act says, there is a form, but the form is not attached over here. This is which.
Sir, it doesn't say form, it says prescribed form. Therefore, it has to be part of the statute.
Prescribed form, no?
Prescribed form.
I'm understanding there is no such form, but what it says, that what kind of informations must be there.
Your understanding will not prevail over the text of the statute. The text of the statute says prescribed form. Where is the prescribed form? Who has prescribed it? It is part of the statute, or any authority has prescribed it.
We do not have this statute. In the statute.
You should be. You should be.
Similar, I need to get that.
That's a very vital thing.
Section 22 form is there. Schedule. Quality.
Sir, we have seen, therefore we are asking
Yes,
repeatedly.
my lord is right. My lord is right.
There is a prescribed form here. Now you come to the latest regulation. You come to the latest regulation.
In a 23
Page 135 you were referring to.
Yes.
Now you come to page 158. Now read that with regulation 5.4 at page 135.
158.
135 and 158. Read regulation 5.4 with 158.
Every application made under this regulation shall be accompanied by a list of
As specified in Form C.
Form C.
Now Form C is at page 158.
Yes.
Where does it say that you are required to disclose whether you are registered in any other board or not? That is only there. Then where is the suppression? So where is the form in the earlier notification? We are asking you, act or notification. You see this form, it says a C regulation 5.4.
Yes, yes.
This is the application form for making a registration.
My lord, if I may.
So this has come into existence much after she was registered in Maharashtra. Therefore, we are asking you, where is the form prevailing prior to this?
It came after. It came after. Maharashtra registration was done in April 2022.
In
April 2022, Maharashtra registration was completed.
April 22.
22.
Therefore, we are saying
This came later.
that is exactly what we are saying. Everything we say is not required to be rebutted.
No.
That's precisely what we are saying. This has come after her registration. So this form was not required to be submitted. What form was required to be submitted under the earlier provision?
To the CCIM.
To the Maharashtra board. There must be some provision.
Then I have to check the CCIM Act.
Huh?
That must be in the Maharashtra.
That must be, has to be.
No, this is Paschim Bengal Ayurvedic System Medicine Act 1961.
61.
The state act.
Yes.
Act. There must be a state act.
But these acts are passed on a particular model. They don't vary from the various states. They don't vary. They are more or less similar in every state.
Normally.
Normally. So there is, because the whole issue is, if the cancellation is after the application, that is one aspect of the matter. The other aspect that you are arguing is whether cancelled or not cancelled, how she can apply. Knowing that she has dual registration, because she was knowing that she has dual registration, which is barred. So where is the disclosure required? Unless a disclosure was required, what wrong she has committed?
Can you see the
She or he has committed.
advertisement? Can you see the advertisement?
No, advertisement says you must be registered with Bengal.
Yes.
She is registered with Bengal. She has registered with Bengal. Because you please try to see why we are asking all these queries. You have come again to page to section 29. Come to section 29. It does not speak of cancelling a certificate because there is dual registration. It speaks of cancelling a certificate if it is obtained by fraud.
Yes.
So where is the fraud we are trying to see? Is the application requiring her to disclose this fact? If not, can it be cancelled in exercise of power under section 29?
Cancellation of registration has not been challenged before the tribunal.
If it is before us, should we shut our eyes?
No, not
If there is a statutory violation, should we shut our eyes to this?
only if her name was struck up from the selected candidate, that
No, her certificate has been cancelled.
cancelled.
Yes, so whether it could have been done. The statute is before us, you are relying on it. You say that under section 29 we are doing it. You read section 29.
Any entry in the register which is proved to be
Proved to the satisfaction means proved.
Proved.
Proved means there has to be some kind of a proceeding after due notice and hearing the parties. Proved to the satisfaction.
Porishad have been
Fraudulently or incorrectly made. So where is the fraud or incorrect step taken by her? If the application form required disclosure of these issues, she has not disclosed, then the situation will be different. If the application form, as it the after 23 application form does not require any such disclosure. Earlier, whether it was or not, we don't know. If it did not require, then the situation will be different. We don't know what we'll do, but this issue has to be seen. And you are not, your cancellation is not for any fraudulent activity also.
No.
You come to page 172. No, not 170. One? Yes, 172. Is being cancelled with immediate in exercise of section 29.
But this was not challenged.
So therefore, we are asking you, should the writ court shut its eye to this statutory violation?
It is a judicial scrutiny.
Yes.
Of the order passed by the tribunal.
Yes.
That point was not agitated before the tribunal in the original application.
All right, you may raise this issue. You may raise this issue. You can raise this.
The cancellation of by the Paschim Banga HON'BLE Porishad was not challenged before the tribunal.
We have already said that.
Can you see the player in the writ petition?
No, not in the writ petition, in the OA.
Application before the tribunal.
Yes.
At page. Yeah. Page 48. A do hereby, paragraph 8A. An order to issue thereby setting aside cancelling the impugned order passed by the Special Secretary House, Health and Family Welfare, dated 6 March 2024. That is one cancellation of the candidature. Correctly responsible to forthwith issue appointment letter in favor of the applicant.
6 March 24. Where is 6 March 24?
March 24 is the order cancellation of
the
not appointment, not recommendation. Cancellation of the recommendation.
Where is it?
Page 96.
Oh, that we have.
This order was challenged. Not the suspension order, nor cancellation of the registration was not challenged before the tribunal.
Yes.
and there was no challenge that cancellation of a registration before the tribunal. Only this page 96 was challenged.
Yes.
If that be so, when a court can go at this stage to the veracity of the order passed by the Parishad or by the Ayurvedic Parishad, cancellation had a registration. Although the root cause is from cancellation of registration, effect is cancellation of his selection.
Yes. That's all. Yes.
Oh,
I'm referring page 51 of my application dot. This is a letter written by the
81.
my petition 101.
101.
She had advocate and it applied for the post of Sango for selected for this mentioned post. But during the verification, failed to provide state registration for that.
Page?
Page 51 of my petition. But doing verification, I state registration for the best.
Page 51 is issued by the West Bengal Health Recruitment.
Another. Enter A at 55. Well, I go to the question. And by this letter, she applied for the temporary registration. On January 18, 2024. She admitted here. I have shared missing at the time of verification. Thereafter,
Page 51.
51.
I had applied for the post.
And thereafter, at page 52, she submitted a time registration certificate obtained from the corporation previously and applied for the temporary. And we have also granted her temporary registration.
So this fact is not there in the other writ petition.
Temporary registration we provided. That is their contention. The temporary registration was given because
she
of
applied, she withdrawn on the certificate
page
before the pressure.
184.
Then why should we refer to the other record, only creating more confusion?
রয়েছে তো চিঠিটা
182.
Which one?
184.
No, 184.
185 and 186.
I think my lord is
Three letters
referring
are
to 185. I think my lord
185. It is
185.
the same. It's the same.
Yes.
The appeal is saying, I don't want to be convicted, so I am requesting you to kindly provide me temporary registration. Is this of consequences? No, that she has done something wrong. That's why she's praying before the pressure. I do not want to be convicted. This is a clear admission by her.
You have not challenged the cancellation of certificate anywhere. Cancellation of certificate has not been challenged by you anywhere. No, therefore we asked you anywhere. We are not saying tribunal. Because rule 30, section 30 says it is to be challenged before the state government. Yes. So you have not challenged.
And according to the section 30, Lordship, says, and like the state government against any decision or order of the person refusing to address person name that registered or removing his name. Therefore, by within 3 months of the date of decision or order of the decision of the state government shall be final. There is no such application before us.
That he has already said. That he has already said.
Think of it. I did not nothing else.
Not challenge the cancellation of certificate. You did not pray even in the OA.
This case may be helping.
So what has the tribunal done?
Tribunal will come to say about once you have suspended thereafter, and they will registration of
Very well.
If you want to accept it, cannot be judged.
Yes.
That's what I. Validity of certificate once accepted cannot be questioned at that stage.
You have not, nobody has placed any judgments.
I did last day. But where reply then?
At the very outset, we told you that this bench has not heard you earlier.
My lord, in reply, I was supposed to, my lord.
Yes, but you have not. That's why we are saying.
My lord, may I respond, my lord?
What reply?
That what he has stated, that it is in the advertisement. It was nothing. I just.
What is there in that
In
advertisement?
the advertisement, it was there that.
That is not for you to say. That is not for you to say. That they have already said. You are not concerned with the
only
record.
one point, that is our real concern, as that the tribunal, what the tribunal actually went on saying, the main contention of the tribunal was that why our action was wrong, why we re-registered, why we have re-registered. That was the main contention of the tribunal. If your lordship sees the gamut of the order, why we re-registered, that means it was right. My lord, re-registration has been permitted, temporary registration by the rule subsequently came in 2023. Only by virtue of this, I am submitting on instruction, because of this tribunal has stated and my lord expressed his anguish. Re-registration is now at present, my lord, stopped. My lord, that part is not right, my lord.
Not relevant.
That
Yes.
part is not right.
So you are relying.
Judgment
Which
is
judgment you are relying?
Yes, my lord, last day. The judgment is there, my lord.
Which judgment?
My lord, the judgment of Maharashtra Medical Practitioners Act, which my lord this Bombay High Court judgment, which was affirmed by the Supreme Court.
You are relying on para 20 of that judgment.
Yes, absolutely. Well,
No, we have not heard you. Repeatedly, I'm telling you, we have not heard you.
I'm forgetting my lord actually. So if I may address on this paragraph, that this issue so far the practicing in another state without having registration or this issue came into consideration as there was no such statute as rightly pointed out by my lordship, that there was no such specific bar. But Maharashtra, when Bombay High Court take this matter in consideration, it held, kindly come to para 20, last line, starts from the last line. May I? Section 29 provides that a person who is enrolled on the central register shall be entitled to practice in any part of India if these provisions are carefully seen. If a person is registered with the state register, he can practice in that state only. But if he is enrolled with that state register and also holds recognized qualification, he can be enrolled in the central register. And once he is enrolled on the central register, he can practice in any part of the country. However, if his name is not enrolled on the central register, he cannot practice in any part of the country except the state in which he is enrolled. Well, at that time, when she applied, her name was not in the central register. And this judgment, my lord, was affirmed. If your lordship sees, my lord, at the very first page, this judgment was affirmed by the Honorable Supreme Court. She can practice only in that state in which, and that is why, my lord, she took registration in the Maharashtra Council so that she can apply for a job. That job also required. This is the, well, I tried to, my lord, place whatever rule and regulations I have in my hand.
Yes.
Kindly do not take me amiss. I have no such kind of that because
you are arguing a case. Why should
that's all.
On this date, Your Lordship, 2014 certificate she returned.
Yes.
If you don't have understood
মানে বোম্বেটা যেটা অ্যাফার্ম হয়েছিল সুপ্রিম
This will be drafted and today's order will be at the party CMA.
পড়ে দাও পড়ে দাও পড়ে দাও My lord, only one thing, that judgment which was affirmed by the Honorable Supreme Court, I also handing over this.
Where we have said relied upon judgment, just add
Which is
subsequently affirmed by the apex. Proceed. Just ignore it. That's why I gave one because it says
see, Your Honor.
when forward legality before a week. That sentinel is that can strike down. This is
On the technical. Nothing. There's a question of relation.
This matter, my lord, I am for the petitioner led by Mr. Vikas Ranjan Bhachar, my lord. Last occasion, my learned senior pen took time for giving the report, my lord.
yes.
Give me some one
Very short time, my lord.
You need more time.
10 days time.
Short time, my lord. I will leave extra to the report, my lord.
How much?
Adjournment.
Where is the filing of report?
This is not reflected, my
From
lord.
where you are reading for filing a report?
My lord, learned pen took time, my lord, for filing report.
It's not recorded in the order. You are supposed to file a report.
No, there is no, want to kindly see the order passed by the tribunal.
No, my lord, this is the question. Regarding my lord, the marks, my lord,
When you
APG
refer to an order, you should not say something which is not there in the order.
my lord,
We rely on what you are saying and then
My
this is
lord,
what happens.
API
Everything, every line we have to check what submission is being made.
API score, regarding API score, my lord, it is found that the marks allotted to a person, my petitioner, madam, API score is lower than that, but he has given the more marks, my lord. Kindly come to the my lord page. This question was raised earlier, my lord, on that day, and learned page took time for give answer to that.
Petition yes, was conducted by the PSC. PSC can answer.
My lord, kindly page to the my lord, page 87, my lord, for my petition, my lord.
You see, the first day as jointly prayed adjourned. Second day as jointly prayed adjourned. Third day, as prayed by you, adjourned. When they have taken adjournment for filing this?
The order, my lord, adjourned.
That's nothing. That's only adjournment 1 week.
No,
What no?
my lord, this
Why
is
no?
my lord, kindly see.
How you are saying no?
Yeah, I have raised this question, my lord.
You have
because
raised 100 questions, but where is
87.
there? Where is that in the order?
My lord, kindly see the 87 page 87, my lord. Here it is found that the API score of my candidate, my
API.
API score, my
What is API?
performance
Index. So we should examine the result.
my lord, application number 5, my lord, my client, who has
Mr.
25.
We are proceeding to hear the matter.
Yes,
All right.
no, my lord. My lord.
Yes, my lord, no.
As because my lord, Ranet senior bench.
You want adjournment, then you say. Don't say that they want adjournment. They are not requiring any adjournment. What do you want? You want to proceed, you proceed.
My lord, I am submitting, my lord. This verification was raised before your lordship earlier, my lord. On that day, Ranet senior bench took time to take in.
We are not accepting this. Now you want to proceed today or you want to proceed? You don't want to.
Tomorrow.
All right.
Ranet senior will come, my lord.
Not today.
Item number 15.
Short time for? Reply is taken on record.
Item number 16.
Yes.
17. 18.
18 and 19, led by Mr. Dibyendu Chatterjee, could not appear before your lordship due to some serious medical emergencies, my lord.
Serious?
Medical emergencies, my lord. They are praying for not today only, my lord.
Mr. Anirudh Chatterjee.
Dibyendu Chatterjee.
Yes.
D. 21. 22.
Your lordship,
Yes.
22-23, there was a direction to file affidavits, your lordship. The affidavit is ready. It will be filed in course of this week, your lordship. Kindly takes it up next week.
Let us see. How many matters?
Your lordship, 22 and 23.
22 and 23.
Yes.
No, third time, they are praying.
Your lordship, the affidavit is ready because due to the vacation, the officers could not afford money.
In both the cases, record the order. In week, leaves after 2 weeks for if they want to file reply in the meantime.
This third time they are paying time.
Let's call the next.
After the
2nd December.
2nd December.
তো এই অর্ডার হলো তো
হ্যাঁ 22 আর 23 22 23 appearance the 24
Your Lordship, Mr. Surya Prasad Chattopadhyay is appearing. He's on his way, Your Lordship. He has instructed that on an earlier occasion, the state was directed to file an objection, but they have not yet filed, Your Lordship.
ফাইল দে
There was a direction twice by your lordships to the state to file a opposition. The date may be fixed, come, this matter may be hard. Taken over direction ছিল opposition ফাইল করা দুবার এক্সটেনশন আছে
24 তো
হ্যাঁ হ্যাঁ
Did you make any request for condonation which has been rejected? Did you make any request for condonation before the authorities?
yes we have
That has been rejected. Where is the rejection?
Lordship takes it on another day, I'll come back, because I was under the impression they have not filed the objection. So,
let us see, where is it? They have not passed any order on your representation. Your representation is at page 40.
It's at page.
Come to page 40, sir.
Yes, page 40. 22nd April 2024.
So they did not pass any order.
No, they have not passed any.
This is under Rule 36.
Yes. Because there is a probably
how much shortfall is of
6 months, not over 5.5 months.
In your case, 5.5 months. No, much less.
7 months. 7 months.
7 months. 7 months. Yes.
8 years minimum for pension. আরে মিন্টু অর্ডারটা আমাকে দেন না দেন না এইটি না থাকে কোথা থেকে দেবো? এই দেখুন,
এই তো আচ্ছা
আমাকে দেয়নি, দেয়নি, দেয়নি।
আচ্ছা বেশ।
কোথা থেকে?
So 7 months can be condoned.
Yes, madam, but
6
because
months.
there is, well, I'll come back, madam, if Lordship wants, madam. The rule book I'm not carrying today, madam. But 6 months, madam, but there is a discretionary power given to them.
Therefore, we are asking you, 7 months can be condoned under what circumstance?
The Lordship takes it tomorrow, well, I'll come back.
You have not filed an opposition.
Time.
Huh?
Maybe extended. Then the impute order, then the opposition file করতে হবে।
Order there, eh?
No.
The xerox করে দিই, xerox করে
Any reply was filed in the tribunal?
Yes, yes.
Reply was filed in the tribunal.
Reply, no, no, nothing, nothing. Only on the point of.
Let us see tomorrow,
Very well, come back.
not today.
Then না কেন না দিন কেটে থাকবে।
কেন ওটা ক্লাসে দিয়ে বাই মিস্টেক না এতগুলো পাতা দিতে পারলাম ওটা তো হয়
25.
For the petition. There was a direction only for the state to bring on record the difference between the petitioner and the other petitioner who has been appointed. There was no formal direction for affidavits, but as PSC has filed its opposition, I am filing my reply to it.
Accommodation.
Similarly situated person has been given appointment, my lord, by the coordinate division bench. On the last occasion, Lordship pointed out that what is the difference between the petitioner in this matter and that matter.
Yes, you were required to tell us. Their job is over.
order. আলাদা আলাদা অর্ডার 15-22 তিনটে হয়েছে।
See paragraph 6 of the order, 5 and 6 of order dated 25/7/25.
দেখেছো?
Did you get any instruction?
I have received a communication, but that pray for some time so that affidavit can be filed.
There is one date after that also on 29/8 it was taken up. Then also you had said that you will be taking instructions.
Last communication received.
Huh?
Last communication received that sometime may be prayed for to file. Sakosai, you requested to pray for some time before the court in order to prepare file affidavit on the strength of views from the PSC.
From the PSC?
Views, government wanted views of the PSC.
What PSC will do? It is your.
No, whatever the stand of the government, that will be disclosed in the affidavit.
Okay. Affidavit in opposition is affidavit in opposition.
$26.
I am for the petitioner, my lord. So that copy was lost, sir. I am just.
All right.
What is your stand?
But allow me to file my last reply, my lord.
We know. Yes. What is your stand?
The order of the tribunal is justified according to us. That has been explained in this. So we have not annexing it, but the fact remains that the tribunal order is justified.
স্যার করছে কম্বল বেরিয়েছে কম্বল বেরিয়েছে শীত করছে
Where you have dealt with 28/7/99? The memorandum of 28/7/99, where you have dealt with that.
Reply to.
Oh, you have accepted. See paragraph, page 12, Roman 8. You have given him a pay and allowances fixed by government under 28/7/99.
That has been mentioned in the order. He wants regularization, which he cannot.
Please read paragraph 3 of our order. You have our order 25/7/25. Have
There will not find in first lordship you find Miller page 4 Miller, Roman 2 Miller, where we have mentioned that where we have
no, if you will kindly see the paragraph 3 of our order 25/7/25, the only issue we asked you to take instruction is here. See paragraph 3 showing. You have got it.
is specific.
So benefit of memorandum dated 28/7/99. Now look at what you have said at page 12, paragraph Roman 8.
Roman 8, my lord. In reply, paragraph 8 of the petition is humbly submitted that the petitioner rendered services throughout the year and
got pay fixation.
Now, thereafter. The respondents further admit that on occasions the petitioner performed duties during many days of the year and that pay was fixed by the finance department memo dated so and so. The respondents deny that mere attendance or frequency of work converts the engagement into a substantive permanent post. The applicable finance department memo and the explicit terms of the engagement letter limit that the legal effect of any such attendance. The respondents further submits that pay and enhanced pay may have been given in consonance with the government's orders for contingent staff and such enhancement do not equal absorption into the permanent service.
Correct.
After we have that's 28/7/99 in reply to paragraph and opposite petition, your respondents admit the content of the memo dated so and so for the limited purposes of this reply and submit that it clearly distinguishes.
Oh, he falls in B. He falls within B.
And expressly states that ROPA rules apply only to the contingency staff mentioned in item A. The engagement of the petitioner falls within the item B, thus the ROPA rules do not apply to the petitioner.
Then he has to file a reply. Yes. An affidavit in opposition.
Let's go for it. I have formulated the question. 27. 99. Mr. Kovik Sarkar is appear for the function. He has not come to court. His grandmother operation. Well, kindly no.
Huh?
Kovik Sarkar is appear for the benefit. He has not come to court due to his.
Not today.
28.
But I appear for the squares. Last occasion, my lords have directed the state to file an affidavit in opposition and petitioner to file an affidavit in compliance.
Opposition has been filed.
I am filing.
My lords, my lords, I have served upon
পাঠাচ্ছে আজকে পকেটে ঢোকাতে পারে দোকানে বলবে ফেরার সময় না আগে
তবে
করে 5-6 পেয়ে গেল।
Yes. What is wrong with the tribunal, sir?
actually, past the point where it has been stated by the its application before the tribunal that he being a scheduled caste candidate, my lords, he was first in line, according to the first point roster, to get the official promotion regarding from being in the post of joint director of additional director of information to the post of press secretary. As the press secretary to the chief minister, my lord, was created as a feeder post to the additional director of information, and bypassing him, a candidate named Shori Kumar Bandyopadhyay was given the promotion to being the press secretary. But in totality, the tribunal has not gone into the point where I have agitated the point, my lord, before the tribunal, that despite he being a candidate of and the first in line, and moreover, my lord, since 2022, my lords, he has been he duly applied for the promotional post, and they just on the technicality that the post has been dated not by the Department of Information and Cultural Affairs, but by the Department of Home. It is not the petitioner's case for official status. But my lord, my point is that my humble submission for your lordship is that this post was facilitated to Department of Information and Cultural Affairs and Department of Home from the lot of the additional data of information. They chose the another candidate, Shorit Kumar Bandyopadhyay, instead of the petition. And my lord, if I may, my lord, there is I would point to an option to page 69 of
Where is copy of your OA?
My lord, the copy of the OA starts from annexure page.
Give us the page, please. No, that is OA 360.
Yes, my lord, yes, OA 452, my lord.
Where is that?
My lord, page 22, my lord.
Where is the reasoned order?
My lord, on page 152. My lord, the order regarding to OA application, my lord.
The reasoned order which you have
132.
25/5/22 order.
I have been asking for different order.
25/5/22.
Yes, my lord, page 134.
134.
134.
So this order of 25/5/22, you challenge this?
Yes, my lord.
Where?
For the by filing this application OA 450 of 2022 before the State Administrative Tribunal, my lords.
Where is the prayer challenging this? Come to page 35.
Yes, ma'am. Yes, sir.
Sorry, page 37. 25/5/22. Yes.
Sir, I stand corrected.
You are Mr. Shamal.
Yes,
Yes. So what is wrong with this order?
My lord, what has happened, my lord? The authority has completely not gone into the fact that first, on the basis of first point roster, my lords, the petitioner has a chance and the first priority and the first right to be given the opportunity to be
When?
from 2022 2002, my lord.
Did you ever become the secretary?
No.
Were you ever posted on that post? You were not posted.
No.
Another person was posted by way of deputation.
Actually, my lord, they say it is deputation, but my lord, on the very words of the press secretary of
Where is the order? Where is the order of his posting?
it's at page my lord, page 77.
When did you retire?
I retired, my lord, in the year 2013. I was in the year 2013.
Date.
My lord, 1st February 2013. My lord, I was supposed to retire in the year 2012, but I got extension 1 year.
So according to you, instead of him, you should have been posted.
Yes, my lord.
And when did you raise the issue for the first time?
My lord, I made an application before the authority, concerned authority. show it to your lordship. My lord, in 2018, man, before the authority, man. Because before 2018, my lord, I did convey to the authority right in 2002, but that proceeding got ended in the year 2017, my lord. If I can show it to your lordship, my lord.
Your first application is in 2018.
Yes, ma'am.
Where is that?
My lord, kindly come to page. What? Before 2018, I made a representation before the Deputy Director of Information. My lord will find on page 76.
76,
my lords. My lord, I stand corrected. It's Director of Information. My lord, I stand corrected. My lord, it is Director of Information to whom I made the representation.
No, how can this be? This is of 97. This cannot be. That person was posted in 2002.
My lord, actually, it is regarding the notification of 1990, on the basis of which he is.
That is not the issue here. That's not the issue. Your issue is that you want to be on the post instead of him. So he became the press secretary in 2002. When did you agitate for the first time? We are asking. After 2002.
My lord, I agitated back in 2002, my lord.
Where is that? Show us. There is some order which has been passed on 17/5/17. Is that an order passed on your representation? Where is the order of 17/5/17? You please come to page 63. Read your prayer A. Where is that document? 17/5/17.
My lord, kindly come to page 92. My lord, because of some ambiguities in on page 92, I have made fresh statements on next page 93.
These are file notings. These mean nothing. These are not orders. File notings cannot be relied upon. These are notings in the file, official files. This cannot be relied upon. This is just intra-departmental communication, does not create right in favor of anyone.
My lord, if may I please your lordship, my lord, if my lords can kindly come to page 98.
Yes, that is all file noting.
Lord, in this order he was released, but there was a point that the authority made that he will have lien on the post of joint director of information, and because the said another candidate Shorit Kumar Bandyopadhyay was also joint director of information. On the basis of this, my lord, he was being overlooked, my lord. If I'm still, my lord, I'm searching for the page, my lord, if I may. My lord, kindly come to page 99. It was a representation made in 2008. From page 99 to page 103, my lords, these are all representation which the petitioner made. My lords will find the rejection prayer on page 104, 17th May 2017, when they rejected the petitioner's prayer, man. Just with a one line, man.
Which page?
My lord, page 104, my lord.
What is that 104?
My lord, the rejection, the petitioner's prayer was rejected, my lord.
That was for your upgradation. Now you want a promotion. You are claiming parity with someone else.
No.
Then you are claiming upgradation of your own post.
My lord, In the way of upgradation, I will get the benefits. I
But now you are claiming a different thing. Now you are not claiming upgradation. You are saying that was a promotion, and because he was promoted, you were an SC, you should have been promoted in his place. That is your case.
My lord,
How can you raise this issue now in such a belated stage? Cannot.
my lord, I have been raising this issue since 2008.
Keep
my lord.
raising. What can be done?
But the ground they are giving, the reason they are given is not satisfactory. Let them decide afresh, my lord, because the
Sorry.
reason my lord,
Yes. What is it? What is your stand? It's on deputation.
Was created by other department.
So how does that make a difference? Whatever department has created it, your stand is that is a single post, therefore no question of reservation. Plus the posting was done by way of deputation.
By home department, not by the information and technology.
So how does that make a difference?
It was created. It was created by the
By the
governor. I'm reading at page 112.
yes. Yes. This is the post creation.
Not a promotion.
It's not in the line of promotion.
my lord, if I may please your lordship, my lord.
Yes.
Lord, if my lord sees the lower portion of this page,
Yes.
the copy which has been forwarded to the departments, my lord. One of the department is Secretary of Information and Cultural Affairs Department, my lord. My lord, this post has been created.
You were not in that department, home department.
I was in the Information and Cultural Affairs Department, my
Yes, not in the home department.
lord. But the Shorit Kumar Bandyopadhyay was also in the same department, my lord.
The senior.
My lord,
Where is his appointment? Where is his appointment on deputation order?
my lord, on page 76. My lord.
Appointment at
77.
77.
Huh?
130.
Same document.
1 minute.
Five 522 order. Where is the page 134?
This by home.
Yes, take down. Third learned advocate for the
of press secretary, though he was appointed on deputation basis.
Yes, next, call the next.
This. 29.
I am for the petitioner. Affidavit of service. Para 6, 7, and 8 are the relevant. Paras.
Challenge this order.
Why not?
Why have you challenged this order?
I have challenged this order under direct recruitment.
Huh?
Under direct, this petition challenging the order of rule framed by the
No. Why have you challenged the tribunal's order? We are asking.
challenged on the ground that my
It should not be heard.
my interim prayer.
What interim prayer? There is no advertisement. What interim prayer will be given? Unless an advertisement is issued for appointment, where is the question of interim prayer?
The department is going to recruit.
Where is the advertisement?
Advertisement has not been.
Then nothing has to be done.
No, Milord, on this point,
Sorry.
Perhaps. Recruitment
the department has already.
Maybe that is different. You may incorporate that. Incorporate it before the tribunal. Call the next case.
That is the entire
Call the next case. Call the next case.
encompasses both.
Item number 30.
I beg to appear for the writ petition, Your Lord.
With the appeal. None appears on behalf of the respondents. Give the date of Monday. Not 70. Date of Monday, make it 19th. Please. 31.
I'm for the petition.
Respond.
Affidavit of service. First case. Unnecessary. Unnecessary. Filing report. He's trying to argue the case. Where's the advertisement?
The advertisement is not, I don't have the copy of the advertisement, my lord. The MS certificate which was issued to the.
Where is the advertisement? Is it part of the OA or not?
Not part of.
Then how your case can be decided?
Advertisement at page 16.
Page 6, yes.
That is the whole thing on which everything is depending, and you are saying advertisement is not there. Page?
16 starts from page 16.
Yes. I'm sorry.
Not bothered to go through the brief.
No, my lord.
Obviously, you have not.
I was of the view that the paper publication.
The whole thing arises out of advertisement. Which clause regarding the certificates?
My lord, if my lord turns to page 18, for meritorious sports person, the last column.
Yes. Where is your certificate?
My lord, the certificate is that page.
Page 26, my lord, if annexure P6.
This is for which sport?
Cricket.
Cricket.
It's an all India level cricket association.
National competition.
National competition. He has participated in the national competition.
And who has issued the certificate?
My lord, it's the Howrah Sports Academy has issued the certificate where he had participated.
So how it is valid as per the advertisement? Come to that. Page 18.
Page 18, my lord.
It will fall in national competition, which is the second clause.
Second clause.
For national competition, the
Secretary of
competent
the State
authority.
Association of the Sports Concern.
Yes. So where is
this is the authority which is owned by managed by the state authority. State Howrah Sports Academy. It's a All India Super Cup cricket tournament where it's an international game.
Sorry. Yes. Our learned advocate for the
In item number 32, my lord, Mr. Shogoto Mitra is appearing, my lord. It is for the pension, my lord. My lord, the petitioner is getting provisional pension, my lord. My lord, since criminal case is pending, my lord, he's not getting, my lord, the full pension, my lord. So, lordship may kindly take this matter, my lord, next week, my lord. Mr. Mitra will be there.
Why next week?
My lord, since, my lord, Mr. Mitra is not here, my lord.
Every day you are taking adjournment. Why?
He's
Last
out of
day also
town,
you
my
have taken adjournment.
lord. Only last chance may be given, my lord. On the next occasion, he will come, my lord, and he will do the matter, my lord.
Not today. Come tomorrow.
Okay.
Thirty-three.
33, in this matter, in terms of the doctor's problem direction, we are filing my immediate opposition.
You are filing?
Immediate opposition.
You are for?
My lord, Mr. Ikramul Bari is appearing.
You have got the copy.
This is relating to my opposition appointment of a
An affidavit in opposition is being.
law of 2 weeks. After 2 weeks. Record if they choose to file reply, if they may file.
And we have already said that.
Thirty-four. I am for the petition. My application, my lord. Well, imping order is dated 29th April 2024. My application was rejected only on the ground of delay. Compassionate appointment.
Date of demise?
Yes,
Your father, your son or
son, my lord.
date of
Initially, my lord. That is a very vital.
date of demise?
Yes. my lord, 19 years, my lord. But my lord, kindly
Date of demise, sir. Why?
yes, my lord. 18 March, May, my lord, 1999, my lord.
18 May
May, my lord.
99.
99.
Working as?
Working as my lord, working as the employee of the state government, my lord, PWD, my lord.
Anyway, so he was in government servant.
Yes, my
Then you made an application.
lord. My lord, and wife. Initially, my lord, wife.
When?
2020, 2001, my lord.
2001, the wife made an application. You
Yes,
have the date.
Yes, my lord. The date is also, my lord, there, my lord. My lord, the 20th February 2021, my lord. If your
Then?
lordship kindly come to my lord, one page, my lord. My lord, they have, my lord, inquiry was made, my lord. Kindly come, my lord, one page, my lord.
No, all right. So inquiry must have recommended.
In 2004, my lord.
Yes.
2004.
When is the recommendation?
Recommended, my lord, 8th, my lord, 1st February, my lord, 8th January 2024, my lord. 2004, my lord. Inquiry was held.
8th January 2004.
And my lord,
Three-member committee.
yes, my lord.
What did the committee recommend?
My lord, they have not sent, my lord, kindly see, my lord, their page, my lord. They have sent it to the superintendent engineer by the, my lord, executive engineer, my lord, for, my lord, take necessary action. They have not take any steps, my lord. During
What was the recommendation? They found the family to be indigent.
they have not sent any report to me, my lord. They have sent the report to the, my lord, superintendent. To
Where
the,
is it? At which page?
Page 46, my lord. Page 46, my lord. Only this letter was sent to me.
So after that letter, what did you do?
They have not that is the internal communication there, my lord, responded, my lord. My lord, by the executive engineer. to
Page
the superintendent.
46.
Yes, my lord. Page 46, my lord.
Report of the inquiry committee.
Yes, my
Why you have not annexed the report?
lord. My lord, they have, my lord, kindly come to the next page, my lord.
Yes. Next page is nothing, sir. This is a letter.
My letter, my lord. They have not served any inquiry report to me, my lord.
So therefore, from 2004.
Yes, my lord. Thereafter, my lord, kindly, my lord, allow me, my
After
lord.
20 years, you filed the.
After, my lord, after that, my lord, my son, my lord, the petitioner here in my lord, got major, my lord. My lord, at the tender age, my lord, the father of the petitioner died, my lord, at the age of 30 years, my lord. 30 years, my lord. During this period, my lord, the mother of the petitioner, my lord, crossed the age, my lord. So, my lord, she requests, my lord, to give the appointment to her son, my lord. They have rejected only on the delay.
Where is the rejection order?
Yes, my lord. Last page, my lord. Kindly come to the last page. Order dated 29/4/2024. The tribunal order.
When did you make your application?
Application, my lord. My mother.
When did you make your application?
2018, my lord.
Yes, nothing can be done. Sorry, just take down.